Call the roll.
Chair Shaheen.
Here.
Vice Chair Busey.
Here.
Representative Isaac. Here. Representative Morales-Shaw.
Present.
Representative Plesa. Representative Raymond.
Here.
Representative Swanson.
Here.
Representative Toth.
Here.
Representative Terry Wilson.
Here.
A quorum is present. As a reminder, anyone wishing to testify before the committee, please register at the kiosk located in the hallway behind the hearing rooms. If you require assistance in registering or testifying, please contact a committee staff member. Due to the number of witnesses who have registered and to accommodate all who wish to testify, there will be a time limit of 3 minutes per witness during public testimony. Committee members, as a reminder, please remember to check out the publicly available comments. These comments are left by the public on each agenda item in our hearings. Comments are open until the end of our hearing and are posted upon adjournment for our hearing. Please let the record show that Ms. Plesa is present. Members, we have a handful of bills to vote out. The chair lays out House Bill 342 by Hayes as pending business. Members, this is a bill we previously heard relating to the combination of certain election precincts. The chair moves that HB 342 without amendment be reported favorably to the full House with the recommendation that it does pass and be printed. The clerk will call the roll.
Chair Shaheen.
Yes.
Vice Chair Busey.
No.
Representative Isaac.
Aye.
Representative Morales-Shaw.
Which bill are we voting on? 340.
3, yeah.
Yes.
Representative Plesa.
Yes.
Representative Raymond.
No.
Representative Swanson.
Aye.
Representative Toth.
Yes.
Representative Terry Wilson.
Aye.
There be 7 ayes, 2 nays, and 0 present not voting. The motion prevails. Chair lays out House Bill 392 by Flores as pending business. Members, this is the bill we heard previously relating to the provision of the reason for rejecting a voter registration application. Vice Chair Busey moves that House Bill 392 without amendment be reported favorably to the full House with the recommendation that it does pass and be printed. The clerk will call the roll.
Chair Shaheen.
Yes.
Vice Chair Busey.
Yes.
Representative Isaac.
Aye.
Representative Morales-Shaw.
Yes.
Representative Plesa.
Yes.
Representative Raymond.
Yes.
Representative Swanson.
Aye.
Representative Toth.
Yes.
Representative Terry Wilson.
Yes.
There being 9 ayes, 0 nays, 0 present not voting, the motion prevails. Chair lays out House Bill 493 by Shaheen as pending business. Members, this is the bill we heard previously relating to the ineligibility to serve as a poll watcher. The chair offers a committee substitute that narrows the scope of the offenses in connection with conduct that is directly attributable to an election to only felony level offenses. Is there objection to the adoption of the committee substitute? Chair hears none. The substitute is adopted. Chair moves that House Bill 493 as substituted be reported favorably to the full House with a recommendation that it does pass and be printed. The clerk will call the roll.
Chair Shaheen.
Yes.
Vice Chair Busey.
No.
Representative Isaac.
Aye.
Representative Morales-Shaw.
No.
Representative Plesa.
Yes.
Representative Raymond.
Yes.
Representative Swanson.
Yes.
Representative Toth.
Yes.
Representative Terry Wilson.
Yes.
There being 7 yeses, 2 nos, and 0 present not voting, the motion prevails. Chair lays out House Bill 1090 by Paul as pending business. Members, this is the bill we heard previously relating to the prohibiting certain individuals from serving as a volunteer deputy registrar. Chair offers a committee subs that adds a provision that terminates the appointment of an individual as a volunteer deputy registrar when they have been indicted for an action committed during the discharge of their duties as volunteer deputy registrar. Is there objection to the adoption of the committee substitute? Chair hears none. The substitute is adopted. Chair moves that House Bill 1090 as substituted be reported favorably to the full House with a recommendation that it does pass and be printed. The clerk will call the roll.
Chair Shaheen.
Yes.
Vice Chair Busey.
Yes.
Representative Isaac?
Aye.
Representative Morales-Shaw?
Yes.
Representative Plaça?
Yes.
Representative Raymond?
Yes.
Representative Swanson?
Yes.
Representative Toth?
Yes.
Representative Terry Wilson?
Yes.
There being 9 ayes, 0 nays, 0 present not voting, the motion prevails. Chair lays out House Bill 1477 by Ms. Swanson as pending business. Members, this is the bill we heard previously relating to the preparation and delivery of precinct election returns, increasing a criminal penalty. Representative Isaac moves that HB 1477 without amendment be reported favorably to the full House with recommendation that it does pass and be printed. The clerk will call the roll.
Chair Shaheen?
Yes.
Vice Chair Busey? Representative Isaac?
Aye.
Representative Morales-Shaw?
Yes.
Representative Plaça?
Is this 1091? Oh, yes.
Representative Raymond?
Yes.
Representative Swanson?
Yes.
Representative Toth?
Yes.
Representative Terry Wilson?
Yes.
There being 9 ayes, 0 nays, and 0 present not voting, the motion prevails. Okay, members, we will now hear bill layouts. Chair lays out House Bill 1297 and recognizes Representative Vode to explain the bill.
Thank you, Mr. Chairman and members. House Bill 1297 is about volunteer deputy registrars, in short, VDRs, are entrusted with the responsibility of officially registering voters in the state of Texas. They are appointed by county voter registrars and charged with helping increase voter registration in the state. They are a vital part of our electoral process in Texas. Volunteer deputy registrar appointments expire every even numbered year on December 31st, requiring in-person training for renewal in many counties that lack virtual options, creating a burden. House Bill 1297 aims to economize this process. This is not a mandate on counties. Again, Mr. Chairman, members, this is not a mandate on counties, rather than an option to make the VDR renewal process more efficient and effective. The bill would give voter registrars the option to inform VDRs that their term will expire at least 1 month before expiration. This notice would come with a renewal application and information provided by the Secretary of State to counties about changes in election law. In summary, House Bill 1297 is a simple bill that can make it easier and more efficient for VDRs to continue their service in the following electoral cycle without the repetitive recertification training. Importantly, this bill does not impose a requirement, but rather give registrars the option to offer this renewal process. Again, thank you, members, and I reserve my right to close.
Thank you, Mr. Vode. Members, are there any questions for the representative? All right, thank you, sir. We recognize your
Thank
right to
you,
close, and we'll
Mr.
go
Chairman.
into testimony. Chair calls Susanna Carranza, representing herself. Give me 1 second, ma'am. Are we, I think. Ma'am, I show you registered as Susanna Carranza. You are representing yourself, and you are for the bill.
That's correct.
Well, welcome, and you can
Thank
start
you.
your testimony. Thank you.
Yes, I am a VDR, and every 2 years I have to renew. And this bill is very helpful because what happens at the end of the 2 years, sometimes if the county doesn't make options available right away, you might have a gap where you cannot help registering voters. One of the things that me and a bunch of us do is we register new citizens. And sometimes, like this year, the first ceremony was January 10. So we had to scramble to go around multiple counties to get recertified so we could serve the citizens that come from multiple counties. If we have the option, because we can't recertify before the year is over, so if we have the option that some counties will offer the option to recertify before our term expire, we don't have to go driving around like crazy all the counties to be able to serve this population. And they might not have an opportunity to register if they don't encounter one of us, because they might not know the process. They're new to the system. And this is not just for new citizens, right? It's really confusing to have a gap on your ability to help registering voters if we could just take care of it like before it expires, so we'll be ready as soon as the term ends. So I urge you to support this bill. It's a simple bill. It's not a mandate, but it's a very helpful tool to allow counties to do that.
Thank you, ma'am, very much. Members, any questions for the witness? Thank you so much, ma'am, for being here.
Thank you.
Chair calls John Mott with the Texas Democrat Party. Welcome, sir. I show you registered as John Mott with the Texas Democratic Party, and you are for the bill.
That's correct.
Thank you, sir. Welcome, and you may start.
Thank you. As the chair said, I'm John Mott, Voter Protection Director for the Texas Democratic Party. Support this bill. One of the things that I've learned in working with voting rights experts across the country is the Texas's voter registration laws are some of the most confusing laws across the whole country. One person can register online, another person can't. One person can change their voting address using this form, but absolutely do not use that form. Volunteer deputy registrars serve a vital role in our process, helping Texans navigate the system. VDRs are experts and help ensure voters and potential voters are able to engage in the voting process without running afoul of the law. This bill removes some of the bureaucratic red tape, makes the renewal process more efficient, and would allow experienced and knowledgeable VDRs to renew their appointments without straining the resources of election administrators and county registers. So I would ask that all of y'all support this bill.
Thank you, sir, very much. Members, any questions for the witness? Thank you, sir, very much for being here. Chair calls Stephen DeLine, representing himself. Welcome, sir. We show you registered as Stephen DeLine. You're representing yourself, and you are for the legislation?
Yes.
Thank you, sir, for being here.
Well, I appreciate you letting me come here to speak. My name's Stephen. I'm here for the bill. I would like you, again, to vote for it. I think this is something that is common sense, being able to allow the population to be engaged with civics is something that can help in a bipartisan way. It's something that helps our democracy. It's something that is very valuable, and being able to make that easier for people to participate is something that I think is really important, especially with things becoming more polarized. Being able to be engaged in the civic process is something that actually psychology studies have shown made it so that people are less likely to take aggressive actions or to hate one another. It's something where we can find common ground, and this is something that's common sense to make it easier for us to get more people engaged in the civic process, and I would like you all to, again, please vote for this.
Thank you, sir, very much. Members, are there any questions for the witness? Sir, thank you very much for being here today.
Thank you.
Chair calls Kathy Hagler, representing herself. Hello, ma'am. I show you registered as Kathy Hagler. You are representing yourself, and you are here against the bill.
Yes, Mr. Chairman, that's correct.
All right, thanks for being here. Please start your testimony.
Thank you, Mr. Chairman and members. I'm a really big fan of personal responsibility, and I don't like the government spending time and tax dollars to do for me what I'm able to do perfectly capable by myself. So if you go to votetexas.gov, the instructions for the VDRs are very clear and very simple. You take the training, you pass the test, you get a certificate of appointment and the forms with the receipts, and you're in business. As long as you follow the rules, your appointment may be, it continues until December 31st of the even numbered year. If you break the rules, your appointment may be terminated by the appointing authority. If you forget the rules, go back to your training or go to votetexas.gov. Boom, that's it. So House Bill 1297 has the county's voter registrar sending out a notice to all their VDRs that their term is about to expire, accompanied by a renewed application. That is tax dollars going out for that notice. Oh, and they're going to send a list of any changes to the law regarding voter registration. So I want us just to think about this session right here. Does anyone think there will be very many changes to voter registration this year? I mean, between executive orders from the president and bifurcation and federal judges and all the stuff that's just happened just in this week, you know, there's going to be a ton of changes for voter registration. This is not the year to say, oh, I read the piece of paper, I understood it all. You don't even have to say you understood it. You just have to say, I read the piece of paper in the affidavit that we have. That's proposed. So in my humble opinion, I think that every single VDR really will need to go to extensive, updated, very different training for all the changes about to happen in this session before their appointment gets renewed in December 2026. I don't trust them to read a letter, because even if they do sign the affidavit saying that they read it, that does not mean that they understood it. If you have to take a test and pass the test to get your certification, that means you understood it. But they will be held accountable to the new law, so they better attend the training. House Bill 1297 has an automatic renewal for the VDR as long as they sign and complete that form saying they read the law changes with no additional training. That might be a good idea next session, but I don't think it's a good idea this session. I love the intent here, but I don't think this is the year for us to give anybody a free pass and an automatic pass-go, do not collect $200 thing. So thank you very much. I appreciate your attention.
Thank you for being here. Members, any questions for the witness? Mr. Raymond?
I just want to be clear on something. Was that a reference to Monopoly?
Briefly, yes, sir. Thank you for paying attention.
Every word. Every word.
Yes, sir.
Does any member have a question about the bill? Thank you, Mayor, for
Thank you,
being
Mr.
here. I
Chairman.
appreciate it. Chair calls Catherine Kano, representing herself. Ma'am, I've been corrected. The record shows that you're Ms. Kano.
Yes,
Catherine Kano, representing yourself, and you are here for the bill.
yes.
Thank you, ma'am, for being here.
I really like this bill. I think because it's a 2-year appointment, having notice provided to registrars, just reminding them that, hey, you may have forgotten, it's time to renew your application, will help people. But I agree that I do not think that we should exclude anyone involved in elections, and most things, but especially elections, from training. I would strongly recommend that y'all consider amending or changing this, this language not requiring training to maybe provide a time frame for training, like 30 days or 60 days within your renewal. Like the previous witness said, there are going to be a lot of changes to election law, and most of the mistakes that are made in elections, I've served as a VDR, as a poll worker, as a polling judge, as a ballot board member, as a central count. Most of those mistakes that are made are resulting from lack of training. That's simply it. So I love this bill, but I strongly recommend that y'all address this lack of training for.
Thank you,
things.
ma'am. Members, any questions? Thank you, ma'am, so much for being here. Chair calls Kevin Hale, representing the Libertarian Party of Texas, and himself. Hello, sir. I show you registered as Kevin Hale, representing the Libertarian Party of Texas, and yourself, and you are here to testify for the bill?
That is correct.
Thank you, sir.
When I got involved in politics, not by choice, but because someone had to do it, I got involved with the Libertarian Party, obviously, and there were, at that time, we had 3 VDRs in our party, and we're down to 1. And this has been over just a 4 or 5 year cycle that we had 3 just a few years ago, right? And the reason that we keep losing them is that because they're not getting a notice about their expiration date, basically. So this is fantastic. We supported this bill last cycle, and we were honored that Representative O asked us to support this bill again, and of course we will. We're confused why this didn't make the consent calendar, honestly. So the Libertarian Party supports House Bill 1297, which simplifies the renewal process for the VDRs. This promotes efficiency and electoral participation. It supports transparent and responsible voter registration by having them sign off on the new updated laws, if there are any, is a great way to ensure that at a minimum they had to read them. They're risking not being able to be a VDR if they lie. So there's plenty of ways to take this away from them if that happens to be the case. So we are strongly supporting 1297, and we hope that you will too, and we'd love to see it on the consent calendar.
Thank you, sir, for being here today.
Thank you.
Members, any questions for the witness? Thank you, sir, very
You're
much.
welcome.
Chair calls Ed Johnson with Harris County Ballot Security and self. Hello, sir. I show you registered as Ed Johnson, and you are representing Harris County Ballot Security and yourself, and you are here to testify against the bill.
Correct.
Thank you, sir. You may start.
Yes, y'all have heard a lot of it from Kathy Hagler and a couple of others here. This is not a good year to undo the training, and that's what this bill does, is undoes the training that volunteer deputies have. We already have had an executive order signed by the president requiring that you're showing proof of citizenship, which is going to make a reference voter registration. You're going to have to now register federally and state. So it's going to be a big change in voter registration here, and people are going to need to be trained on how to do this. So this is not a good year to skip training.
Thank you, sir, for your testimony. Members, any questions? Thank you, sir, very much for being here. Is there anyone else who wishes to testify on, for, or against House Bill 1297? If not, the chair recognizes Representative Vo to close on the bill.
Thank you, Mr. Chairman and members. House Bill 1297 was filed as HB 2351 last session and received a strong bipartisan support and passed the House last session. House Bill 1297 is a simple bill that gives counties the option to streamline the recertification process. It permits registrars to appoint repeat VDRs without administering repetitive training by instead providing them with notice of new election laws when continuing their service. And with that, I close.
Thank you, Mr. Vo. Members, any questions?
Yes, Chairman, please.
Yes, ma'am.
Yeah.
Morales Shaw.
Okay. Yes, Rep. Vo, hearing the testimony that we heard today, I would have some concerns about the new laws that are coming down, and I was just wondering if there is a way that you can make concession for that and still give the voter deputy registrars the opportunity or option, as the first witness said, to be able to recertify earlier so that at the last minute they're not running from all these counties trying to get re-registered. Is there a possibility to have both in your bill?
Let me look into it, and we'll get back with you.
Okay, all right.
Thank you, sir. Any other questions? Thank you, sir.
Thank you, Mr. Chairman.
If there's no objection, the bill will be left pending. Is there objection? Chair hears none. The bill is left pending. Chair lays out House Bill 376 and recognizes Representative Hayes to explain the bill. Welcome, sir.
Thank you, Mr. Chairman and committee members. The Texas Election Code sets forth the requirements related to a plan for a central count station operation, often referred to as central count for certain elections in Texas. Originally added in 1985 to the Election Code, the only requirement was to have a written plan for the orderly operation of the central counting station. That section has only been amended twice, in 2011 to include the process for comparing the number of signatures to the combination form to the total number of votes cast for the entire election, and then again in 2017 to require the plan to be available upon public request by 5 p.m. the 5th day before the date of the election. Well, guess what's happened? Technology and processes have changed significantly over the past 4 decades, but the requirements for central counting station plans haven't kept pace. This House Bill 376 establishes best practices by updating the requirements for a central counting station plan. House Bill 376 adds several elements to the plan, including but not limited to adding electronic poll lists to the method of comparing the number of voters who signed in to the number of ballots actually cast, the date and time and place of the second and third logic and accuracy tests, and the procedures if there is an unsuccessful test, the date, time, and place for central counting station operations before, on, and after Election Day, who will provide information to the presiding judge to complete reconciliation of votes and voters, ballot security procedures, including ballot storage and chain of custody, information regarding live stream available to the public, which shows all areas containing ballots from the time ballots are delivered to the central counting station, posting of the central counting station plan on the county's internet website. House Bill 376 is a refile of House Bill 4399 that was passed by the House last session. We had worked with multiple stakeholders to substitute, amend, and pass the bill out of the House, sending it over to the Senate, where it languished until its ultimate demise. Here's to hoping for better results this session. Thank you, Chairman Shaheen and members of the committee, for giving us an early hearing. I believe we may have witnesses, so I yield and reserve my right to close.
Thank you, Mr. Hayes. Members, any questions for Representative Hayes? Thank you, sir. There are no questions. We will proceed to testimony. Chair calls Kathy Hagler, representing herself. Hello, ma'am. I show you registered as Kathy Hagler. You are representing yourself, and you are here to testify for the bill.
Yes, Mr.
You
Chairman,
may
thank you.
proceed. Thank you for being.
Okay, so what happens in the central counting station is a little bit of a mystery to anyone who hasn't been in the central counting station before. I'll just call it CCS. My best explanation for CCS to most people is that's where the election sausage is made. Representative Hayes is giving us a great bill to take some of the mystery out of it by requiring more transparency, more detailed information in the plan, and it'll be made more accessible to the public. So he's already talked about some of this, but the plan will help the leadership plan in advance of when it needs to happen. It prepares those who will be involved on the CCS team to know more about what their responsibilities will be, and it also helps them to hold their leadership accountable to the plan. It offers transparency to candidates and voters who aren't in the CCS, and it also provides CCS poll watchers the information they will need to know so that they know when the CCS will be meeting. So that whole plan concept was introduced in 2017, and now for a couple of years we've had a CCS handbook, which the SOS produces, and it's been very helpful in guiding presiding judges and CCS managers as to what should be in the plan. But I say should because, as we keep having to say, SOS has to recommend or suggest or strongly suggest great ideas that are not in the law. So now we have a law. Proposed. Representative Hayes filed a similar bill last session that made it through the House, died in the Senate after being referred to State Affairs, but I'm very pleased to say that I checked the record, and Vice Chair Busey voted for House Bill 4399 on the third reading on May the 12th, so that's very impressive, Representative Busey. I know a lot of work was done last session to negotiate amendments and working with the county clerks and EA associations. So now that we've got all the bugs worked out of this from last session, this should be a no-brainer. So the new CCS plan would let us know who is providing the information that's required for that very important reconciliation form at the end of the processing on election night, when and where the second and third LNA tests will be conducted, the schedule for all of the CCS meetings, the names and party affiliation of the people on the team, but none of their personally identifiable information, the procedures for ballot security, and information for the live stream. And rather than a county clerk or an EA having to stop, drop, and roll because somebody walked into the office and they're needing to get a handout of the central count plan, now this would be available on their website. So it's available to the public on the website, and it's easier for everyone. It also provides that if the plan is changed, They're supposed to have a revision date and tell us what was changed so that each time we don't have to review the whole plan to see what changed. It's a really great bill, and I appreciate you supporting it.
Thank you, ma'am, very much. Members, any questions? Thank you, ma'am, for being here.
Thank you, sir.
Chair calls Catherine Cano, representing herself. Hello, ma'am. I show you registered as Catherine Cano. You're representing yourself, and you are here to testify for the bill.
Yes.
Thank you, ma'am. You may proceed.
I really like this bill. As someone who is very interested in processes and methodology, I think it elaborates on what's already required in a way that makes sense to me. Granted, I've never had to write a central counting station plan, but I have read them. I've participated as a judge, a presiding judge, and an alternate judge in central counting, and this all seems really good to me. I also very much appreciate the last provision in here, which will, it's the contact information of a person described by subsection B5, which is the members of the general counting station, essentially, is not subject to disclosure under Chapter 552 of the Government Code. And I would just like to say thank you for including that, because it can be scary to worry about getting doxxed. And yeah, that's just really good. I appreciate this bill.
All right. Well, thank you, ma'am. Members, any questions? Thank you, ma'am, for being here. Is there anyone else who wishes to testify on, for, or against House Bill 376? If not, the chair recognizes Representative Hayes to close on the bill.
Thank you, Mr. Chairman. Committee members, I close.
Thank you, sir. Members, any questions? If there's no objection, the bill will be left pending. Is there objection? Chair hears none. The bill is left pending. Thank you, sir. Chair lays out House Bill 1783 and recognizes Representative Paul to explain the bill.
Thank you, Mr. Chairman, members. It's good to be before you again. This is a bill that we passed out of this committee and off the floor last session. Well, I'm sorry, got it out of committee, had an issue on the floor. But the Senate's office has passed it a couple of times. And what this is a bill to take care of situations that arise in local communities where they have a ballot proposition that comes up. And the language for that ballot proposition is very confusing to the voters. In fact, as an example, we had one in Houston that you had to vote no to pass it. So a lot of times the locals will use these to try to mess up with the voters or confuse the voters, especially if it's a initiative brought up by petition that they don't really want to deal with. So what this bill does is sets up inside the Secretary of State's office a way, if a citizen wants to bring a charge and say, hey, we want to get this reviewed, the Secretary of State's office can review that language, and if they have a problem, they send it back to the entity can then fix it and send it back. If they have another problem with it, they can still review it and send it back. If it gets to be a third time, then they're going to be classified as a bad operator, and the Secretary of State's office would have to write their ballot initiatives for them. So it's a good bill to make sure that the citizens know exactly what they're voting for. It's a good bill to make sure that people that put their initiatives on will be able to have their initiatives actually voted on. And so I think it's a good cleanup thing, good cleanup bill. But it's a good bill to help justice and
Mr. Raymond.
Thank you, Chairman. So, you know, when we pass a constitutional amendment here, and obviously it passes and we send it out to the voters, like we will, no doubt this year, pass some, our bill, the bill will say what the ballot language is, right?
That's right.
And so with yours, this is local, or what, I mean, what is it?
Yeah, this would deal with local governments. So it's a way to make sure that, and look, if nobody says anything, I mean, the way it's set up, a citizen has to complain, right? So if the citizen complains and says, hey, this doesn't look good to me, then that would situate the situation up. If the ballot language comes out from that local entity, it makes sense, nobody's going to complain, and it's never triggered.
I guess what I'm asking is, what do you, I'm trying to figure out how, because, by the way, I mean, I think, I know I speak for myself that, and I've seen this stuff too, where it's confusing and people are confused, and I don't like it. So I'm glad you're trying to do something on it. But I'm trying to anticipate, so if the city council passes something, and the council itself, they pass it, and just like we vote on the actual ballot language, so when a council, let's say city council passes, and in their vote, where the council themselves vote, they vote on what the actual language is.
That's right.
Shall be on there. So were your bill to become law, the public or somebody can go complain about the way the council passed it?
Exactly.
Okay.
So if somebody complained about what that ballot language was, so that doesn't make the Secretary of State's can review every one of these all across the state all the time.
Right,
That's not
right.
the case. If somebody complains and actually has an issue with it, then they'll review it. And they might review it and say, this looks fine, there's no complaint, there's no warrant, and send it back, and it's okay. But if they do find that there's a change, they'll tell the city what you need to change, and they could change it. The city would rewrite it themselves and send it back to the Secretary of State for review.
And so you have a head start, because you said you did it last session. I wasn't on this committee, so I
Yeah.
apologize.
The Senate's passed it 2 times, and we've got it out of this committee 2 times, but it had some kind of a issue with the caption that had a point of order on it, not really with the bill.
Yeah, but I'm trying to figure out, like, how you think it plays out, because I can promise you, there probably will be complaints. I mean, it's a big enough city, you're gonna have a lot of people, and somebody will complain, right?
Yeah.
And so I'm trying to figure out how we can do this in a way that moves us forward, but that, doesn't lead to frivolous stuff. You know what I mean? Like somebody,
follow what you're saying.
like somebody's against it. They know what it is, and they're against it, so, well, I'm gonna complain, so
But
that
the Secretary of State would review it, send it back, say this is fine. So that.
So we're kind of leaving it then, we're giving the Secretary of State those four folks over there to my right, those folks, we're leaving it to them
They love us.
to be the judge and jury, basically?
They will review it and make it an issue. If it does become a legal issue, the bill applies for a rocket docket that could go through a court, and a judge will have to review this and say that the judge is going to make
The
it.
district judge or what? I guess?
Yes.
Okay, and so then, if the district judge says, Secretary of State, these fine folks, no, I think they're wrong, the language is fine.
Then the language would be fine.
But then, if I don't agree with that, then I can appeal it. Is that right? I guess I could appeal it.
Well, I guess.
But again, you're going to make it where it's
Yeah, any kind of legal ruling, I think
expedited.
you can appeal it.
I didn't see
Yes,
it.
it's expedited through the court system because the election is coming up.
And, okay. Yeah, I mean, I like where you're trying to get. I'm a little, did Busey vote for it last time or not?
Busey's all for it, man.
Did he vote for it? Did he vote for it or not? He didn't?
Hey, he's voted for a lot of Paul bills. There you go.
Well, it was going to give me a clue, so he voted no. But I like where you're going, because I agree with you. You know, members, I don't know if y'all's experiences, but I feel like we actually do a better job in our HGRs, in our ballot language, than a lot of these cities do. Oh my gosh, or at least, I'm sorry, than Laredo does.
And Representative Raymond, that this is something that's repeatedly gone on in our local community.
Yeah.
Time and time and time again, where we've had this problem. And in fact, sometimes the cities the citizens would put a ballot on through ballot initiative, and the city would put something else on for the same thing that would say something different, just to make you vote on both of them at the same time.
I'm leaning very heavily toward being, I mean, you may have the votes already, I don't know, but I'm leaning very heavily in favor, because I think you're trying to address something that needs to be addressed.
That's right. It's
So-
from, and look, everything that we're doing here is just trying to make sure that voter has a good, clear
Absolutely.
ability to make a decision that's based on
Yeah, because
that.
most of the times when they got to vote, they're voting on getting taxed more, you know?
Yeah.
And I don't like that, I mean, it's got to be clear, man.
Got to be clear. And like I said, I'm not making this up. You had to vote no on it to pass it.
I believe you.
Yeah, right. And that's exactly what we're trying to get at. So I
Thank
think
you,
it's
Chairman.
just good, clean government.
Thank you, Chairman.
Members, any other questions? We will proceed to testimony. I'm assuming you want to reserve your
I
right
will
to close.
reserve the right to
You
close.
got
Thank
it.
you, Mr. Chairman.
Yes, sir.
Members, appreciate it.
Yeah. Chair calls Veronica Worms with the Texas Civil Rights Project. Welcome, ma'am. I show you registered as Veronica Worms. You are you're representing the Texas Civil Rights Project, and you are here to testify against the bill. Is that
Yes.
correct?
Yes,
Okay, thank
Chairman.
you for being here. You may proceed.
All right. Thank you, Chair Shaheen, Vice Chair BC, and committee members. My name is Veronica Worms, here today representing the Texas Civil Rights Project against HB 1783. Specifically, we oppose imposing a oversight regime on ballot proposition language under the discretion of the Secretary of State's office. Under this bill, the Secretary of State, who is an unelected political appointee, would have the unilateral authority to determine, in that official's judgment, whether a city's proposed ballot proposition language is misleading, inaccurate, or prejudicial. The Secretary can then request that the city redraft the proposition to correct the defect up to 3 times, after which point the Secretary can just redraft the proposition. This 3-round back and forth process could easily take a number of weeks, and after that time, if the city opposes the new ballot language, the parties involved will end up in the same place they currently do, in court, where the dispute may very well take even more weeks or months to resolve. Overall, this bill will just limit the amount of time that local governments have to actually prepare ballots for upcoming elections, while doing nothing to prevent local governments or the Secretary of State's office from ending up in a court dispute over ballot proposition language. Given these concerns, we urge the committee not to report this bill favorably. Thanks.
Thank you, ma'am, for being here today. Members, any questions? Thank you, ma'am, very much for being here. Chair calls Emily French with Common Cause Texas. Welcome. We show you registered as Emily French, and you are representing Common Cause Texas, and you are here to testify against the bill. Is that correct?
Yes, sir.
Okay, well, you may proceed.
Thank you. I'm here today to testify in opposition to HB 1783. We understand that misleading ballot proposition language is a problem, but we do not believe that HB 1783 solves that problem. The bill proposes a process for the Secretary of State's office to rewrite ballot proposition language that they find misleading, inaccurate, or prejudicial. But this process proposed by HB 1783 is filled with holes. We agree with Representative Raymond that opponents of a proposition will always be bringing this to the Secretary of State, which would allow bad faith actors to clog up their office with requests for review. If the SOS does not approve the ballot language, they can reject it up to 3 times, but the bill does not require that office to say why they are rejecting ballot proposition language, which could mean that a city wastes 3 rounds of edits blindly trying to fix the wrong thing. After that third strike, the SOS's office gets to rewrite the language themselves. This provision creates an opportunity for an unelected political appointee to put a thumb on the scale in a local ballot proposition race. Supporters of local ballot propositions could spend a great deal of time and money convincing local voters of their position, only to find the language stacked against them by the Secretary of State. While we believe that this Secretary of State's office would treat cities fairly in this regard, we cannot count on future offices to show the same restraint when reviewing ballot language that they personally dislike. Given these concerns, we urge the committee not to report this bill favorably. Thank you.
Ma'am, thank you for being here. Representative Toth?
What should be done, in your estimation, or in your opinion, I should say, about confusing ballot language?
Absolutely. Secretary of State review process could be good. I think requiring the Secretary of State to say why they're rejecting that language, perhaps having a local committee that votes on it.
Have you come in before this committee before and asked for clarification on these ballot initiatives and any ideas?
Yes,
other
sir.
than criticizing this bill?
Last session when this was, I believe it was SB 221, we came before this committee and said much the same thing. I would love to see sort of the same process that appoints election administrators, perhaps, representing both parties, both sides, some local officials, in addition, perhaps, to a Secretary of State review. I think there's a lot of things we could do.
Okay, thank you.
Thank you.
Members, any other questions? Thank you, ma'am, for being here. Chair calls Kathy Hagler, representing herself. Hello, ma'am. I show you registered as Kathy Hagler. You're representing yourself, and you are here to testify for the bill.
That's correct, Mr. Chairman.
You may proceed.
Thank you, Mr. Chairman and members. You may recall a few years ago when the legislature passed a law requiring a 1D and 1R to go with someone from the EA's office to the nursing home. to assist the residents with their ballots. I know that was a constitutional, we're talking about local, but just hear me out. As you might guess, I was the R on the team from my county. We would read those constitutional amendments to senior citizens in the nursing home, and we would get blank stares. They would say, well, what does that mean? Or is that a tax increase for me? Or what does it do if I say yes, and what does it do if I say no? Because everything was so completely unclear to them. And obviously, we could not explain to them anything, so we could only read again, maybe a little slower, maybe a little louder on the words that might help answer their questions, but we were not allowed to give them anything other than the language that was on the ballot. More often than not, they would just skip it because they couldn't understand it. So we also had some testimony last week about double negatives and triple negatives in some of the language of these bills. And you have to admit that sometimes even you have to read and reread an amendment to figure out if you're going to vote for it or against it based on the way it's worded. And as I mentioned before, I know that HB 1783 is about city propositions and not about state constitutional amendments, but the principle is the same. People need to be able to easily understand them, so we have to do something. And then the plan for teams going to the nursing homes, by the way, was an abject failure, and it was immediately reversed by the legislature after that constitutional election because it didn't work. But I think that this is the answer to help alleviate the problems. They have to have, I believe Rep. Raymond called it a judge and jury. They have to have a judge and jury somewhere to settle the differences if the city is wording it differently or wording a proposition so that it can't be easily understood. I think we're going in the right direction with this bill. Thank you.
Thank you, ma'am, for being here. Members, any questions? Thank you, ma'am. The chair calls Andrew Hendrickson with the ACLU of Texas. Hello, sir. I show you registered as Andrew Hendrickson, and you are representing the ACLU of Texas, and you are here to testify against the bill?
That's correct.
Okay, welcome. You may proceed.
Thank you, Chair Shaheen, Vice Chair Busey, members of the committee. I think most of my points have been covered already by my colleagues Veronica and Emily, but a couple of things I did want to point out. In response, I think, to Representative Toth, to your point about where and how we address this, I think this actually represents a bit of a separation of powers issue by taking a member of the executive branch and asking them to determine whether the law is being complied with. The proper venue, I think, for that would be a court system. That would be, to me, the proper place where the determination about whether the ballot prop language actually complies with the law would be adjudicated. I would also note that while the bill does discuss a mandamus action brought by a citizen of the city against the city, it actually does not mention anything about how a city could sue or any mechanism by which a city could appeal the SOS's ruling on the rewritten language after that third rejection. There is nothing in the bill that actually talks about the appeal process for a city who wants to challenge that, so it's unclear exactly how that would play out if the ballot is rejected 3 times, if the language is rejected 3 times. That, again, so completely within the Secretary of State's discretion. And then I would also say that, you know, one way in which the bill also, I think, presents some problems is that it adds this language about how a proposition must substantially submit the question with such definiteness, certainty, and facial neutrality that the voter is not misled. None of that is defined. There's no further guidance provided by the bill as to what that means. That is a fairly open-ended thing to be interpreted by the Secretary of State's office. And given that they're not required to provide an explanation for the rejection, it is potentially subject to, and again, I agree with Emily, this Secretary of State's office, fine, but subject to potential abuse for rejection of language that that they disagree with because it's a progressive ballot proposition and they don't want it to pass, in a city where the Secretary of State may not agree with what is being proposed on the ballot, and for political reasons may potentially reject the claim, no explanation, rewrite the language themselves in a way that is actually potentially more misleading. I think it creates that risk. I'm not saying that's necessarily what will happen, but I think that risk is mitigated if you place this review process where it belongs in the judiciary, where there are systems set up to make sure that both sides are equally represented, everything happens according to the due process laws that we have in our civil courts, and everything can be fairly adjudicated with fair representation by both sides and in the open.
Thank you, sir, very much. Members, any questions? Thank you, sir, for being here today. Chair calls Ed Johnson, representing himself. Welcome back, sir. We show you registered as Ed Johnson, representing yourself, and you are here to testify for the bill.
That is correct.
Thank you, sir. You may proceed.
Just explains Representative Toth some of the things that have been brought up here. One of the reasons for this bill is that the court system, to allow a proposition that is fixing to be on the ballot, usually this is a petition ballot proposition that the city may not be 100% in favor of, and that's why you're getting some weird language, because they're trying to make it as confusing as possible. And then if you would have to send that to court, you would not make the time that the election department needs to be able to put this issue onto the ballot. So that's the reason for giving this to the Secretary of State, so a very fast decision can be made that can correct the language and then be able to have the issue placed on the ballot. If you miss that, it's another 2 years before you can have it on the ballot again. So it's very important that this needs to be a very timely decision, and you don't have time to send it through the court system.
Thank you, sir, very much. Members, any questions? So, Mr. Johnson, we have you registered twice.
Registered twice?
And are you okay if we delete the registration that shows you not testifying?
Yes, please.
Okay. Hold on.
I'm sorry to make confusion.
Okay, we got it cleaned up. Thank you, sir.
Thank you.
You bet. Yeah. Ms. Christina Atkinson, if you could come up, please, as a resource witness. Ma'am, I show you registered as Christina Atkinson, representing the Secretary of State's office, and you are neutral on the bill.
That's correct, yes, sir.
Thank you, ma'am. Recognize Mr. Busey.
Hey, Mr. Chairman, can you walk us through how this process works now and how the process will change under this bill?
I'm sorry, hold on just one second. I want to make sure that we're good. Ms. Atkinson, could we ask you to register real quick?
Sure.
Actually, your colleague's registered, but you're not.
Okay. Sure.
Or, why does Gabriel?
I can do whatever.
Actually, why don't you just register? That'll be the safest thing.
Sure. Easy right here. Piece of cake. Yeah. Yeah, you got it. I thought I was, so apologize for the.
Okay, ma'am, I show you registered as Christina Atkinson, and you are representing Atkins. You are representing the Secretary of State's office, and you are neutral on the bill.
Yes, sir, that's correct.
Thank you for being here, and you may proceed.
My pleasure.
People are. Thank you, Mr. Chairman. Can you walk through how this process works today and how it would change in this bill? Because we had questions about what if after third strike, is there an appeal process? So just if we can understand what we would be changing under this law.
Sure, of course. I think under current Texas law, if there are individuals within a community that are unhappy with how a ballot proposition is going to be worded for an upcoming election, and remember, we're talking specifically about home rule cities, initiative and referendum that they might have, or city charter amendments, the remedy for modifying that language now would be either to make a direct appeal to the city in some way, shape, or form, and depending on where we are on the election calendar, there may be some actions the city can take. More than likely, it's going straight to court under current law. What I see under HB 1783 is that this process, or what this bill does, is it creates, I think I would call it an administrative review process of that ballot language, whereby somebody could make that appeal to our office. Our office would have the ability to work with the entity. There's a potential for a back and forth to try to resolve the discrepancies or the differences with that ballot language. And then ultimately, our office would decide the ballot language if the entity is not able to resolve it on their own.
What court does it go to right now?
Probably a district court.
So there's not one court, it's local, it's going to happen. I'm just asking because the last witness talked about the courts would take long, and I'm just wondering how that is a longer process than sending all of these all over the state to one office, to you, and it sounds like we'd almost be backlogging you as opposed to going through the many different courts. I mean, because now it goes to many different places. And you said immediately, and instead this bill would make it go to one central place, so we could have a lot of these issues happening at the same time around the state. And then there's a 3-time back and forth potentially, right?
Yes, sir. That's what the
That
bill
seems
says.
like a longer process to me than going to the local court. And so I'm just trying to understand why the last witness was talking about that would take too long through the courts, where this seems like this could take longer. And I'm just trying to understand the logistics. But so one central hub, potential having to deal with state issues all over the state versus many hubs under the current policy, and starting immediately instead of a 3-time back and forth.
Yes, sir.
Okay, so I don't know that the time complaint we heard earlier makes sense. What about after the 3rd time? Is there another appeal process, or if it can't be agreed upon, then Secretary of State will write it?
Correct, yes, sir. And I think at that point, if there is an individual that's unhappy at that point, or the entity's unhappy, I think that the remedy then would be to go to court.
So then they could go to court if they wanted to?
Yes, sir.
Maybe, because obviously we tend to always have that option. Okay, I guess finally, if you write it, then that's not the local elected officials writing it at that point, correct?
That's correct.
So the people in this community elected these local officials, they have this oversight, and this will be taking away that local official authority and giving it to the governor-appointed Secretary of State.
It would be placing that authority in our office, yes, sir, in the Secretary of State's office.
All right, seems like then what we're doing is taking away the ability of local elected officials to elect their local leaders and then write these propositions. Thank you, ma'am.
Members, any other questions? Thank you, ma'am, for being here. Is there anyone else who wishes to testify on, for, or against House Bill 1783? If not, the chair recognizes Representative Paul to close on the bill.
Thank you, Mr. Chairman. Members, kind of go over some of the things that were addressed there. Number one, in this process, going back, it was said that they wouldn't tell the local entity. Obviously, they're going to tell the local entity what their issue is, and the local entity would rewrite that. And if it's cured with that, it goes on forward. It stopped right there. If they didn't do it a second time, you'd have the second or third time come in, and then they would write it. So the local entity is always going to be writing that bill. Also, as far as an elected official, we know there's no elected official in the city of Houston writing these, or some of their staff are writing these and doing it. They do vote on them, but it's not hardly some elected officials' right being taken away from them. If they write a ballot that would secure the people of what they want to get done with it, they wouldn't have a problem in the first place. And finally, there is a process to make sure this does go to the court and do it. But the idea is instead of putting these in district courts all over the place, there would be a way to cure it and get a process in place without bringing in the court and all that expense and cost of a court case and doing it. So you're going to be able to save the local entity as well as individuals to get that done. And I wouldn't think that they're going to get swamped with these unless you think that the local entities are writing bad ballots all over the state. If you think they're writing fine ballots, then I doubt the Secretary of State would be that busy.
Mr. Busey?
What, because I know it's a back and forth, how many, is it one person? Can you walk through the process of how to challenge it under this? And I know that it goes into the
I think one person could challenge it, yes.
So in the city of Houston with millions of people, it takes one person? Okay.
That's right.
That's all I need to know. Thank you.
Members, any other questions? Thank you, sir. If there's no objection, the bill will be left pending. Is there objection? The chair hears none. The bill is left pending.
All right, thanks a lot. I close. Appreciate it, gentlemen.
You bet. Okay. Chair lays out House Bill 1478 and recognizes Representative Kane to explain the bill.
Thank you, Chairman Sheen, Vice Chair Busey, members. The National Voting Rights Act mandates that states keep accurate and up-to-date voter rolls to ensure that all eligible voters are properly registered. Texas law requires voter registrars to remove individuals from the voter roll who are ineligible to vote. In 2021, the legislature enacted Senate Bill 1113, which imposed penalties on voter registrars for failing to remove ineligible voters from the rolls after receiving notice of the voter's ineligibility. The penalty involves the withholding of Chapter 19 funds. In 2021, the Harris County voter registrar was informed by the Secretary of State about voters who were ineligible to vote, but the voter registrar refused to remove those voters from the voter roll. However, when the Secretary of State threatened to withhold Chapter 19 funds, the ineligible voters were removed from the roll in 2022. Besides cancellation by notice, a registered voter can challenge the eligibility of another voter to be removed from the voter rolls. Unfortunately, Senate Bill 1113 does not address challenges made by registered voters. In the fall of 2022, registered voter Alan Vera submitted challenges to the Harris County voter registrar for over 600 voters who were registered using post office boxes. The passage of Senate Bill 1111 in 2021 mandated that voters cannot be registered at locations that are impossible to reside in, including P.O. boxes. As of now, the Harris County voter registrar is yet to address Mr. Vera's challenges. Presumably, these voters are still registered in illegal locations. However, this bill would extend the penalty for withholding Chapter 19 or 31 funds if the voter registrar fails to perform their duties in a timely manner under the Election Code, which requires the registrar to approve, change, or cancel a voter registration, schedule a hearing on a challenge, or decide regarding a challenge. This bill will provide an incentive for voter registrars to maintain accurate and current voter rolls as required by federal law. Thank you. Have some questions. We'll come back and close later.
Thank you, Mr. Kane. Members, any questions? Thank you, sir. With that, we will proceed to testimony. The chair calls Veronica Warms from the Texas Civil Rights Project. Welcome back, ma'am. I show you registered as Veronica Warms, and you are representing the Texas Civil Rights Project, and you are here to testify against the bill.
Yes, sir.
Thank you, ma'am, for being here. You may proceed.
Sure. Our main concern is that there are no guardrails built into this bill. The Secretary of State could withhold seemingly any amount of money from elections offices who do not timely, in their judgment, address a voter registration challenge. This is an unnecessarily punitive proposal that will, one, not inherently get these challenges addressed faster, and two, could lead to disparate treatment between counties on how these withholding decisions are distributed. Moreover, as drafted, HB 1478's punishment for counties could be meted out for a one-day delay in scheduling a voter registration challenge hearing, a huge penalty for counties that are already struggling to meet election law requirements with the limited resources at their disposal. We would encourage this body to provide more funding to counties that are struggling to meet deadlines because of staffing and resource constraints, instead of putting this proverbial stick into the code that has the potential to make the situation it's trying to remedy worse. We ask the committee not to report this bill favorably. Thank you.
Thank you, ma'am, very much. Members, any questions? Thank you, ma'am, very much for being here. Chair calls Emily French with Common Cause Texas. Welcome back, ma'am. We show you registered as Emily French. You are with Common Cause Texas, and you are here to testify against the bill.
Yes, sir.
Okay,
Yes.
thank you. You may proceed.
Thank you. Testifying on a bill about Harris County against Representative Kane. I'm sorry, I hope it's not too unpleasantly vintage House elections for folks, but I am here to testify in opposition to this bill. I believe it would hold county funds hostage in an attempt to make voter challenges more important to counties than voter registrations. Existing law already requires counties to timely process voter registration challenges. The election code says that a challenge to a voter registration not based on residence must be scheduled within 20 days. Challenge of cancellation hearing must be scheduled within 10 days. Mail notices for residence-based challenges must be sent out promptly, just as determinations after the hearings must be made promptly. Voter registrars are handling an immense amount of paperwork, especially in election years, which we could cut down on with online voter registration. Radical activists have been known to deliver voter challenges en masse. In Travis County, one person has challenged the registrations of 12,000 people. In Brazos County, a group challenged more than 1,000 voters. Collin, Hayes, and Tarrant County have each received more than 10,000 challenges. These challengers often lack personal knowledge, making many of their challenges invalid. HB 1478 would encourage bad actors to wait until the voter registration deadline, then drop thousands of frivolous challenges to tie up voter registrars' time and slow their processing of new valid voter registrations. This bill also proposes a solution that makes the original problem worse. If a county is too slow to process challenges, then they lose funding, which could force them to lose staff, which would make it harder to process challenges. We believe this bill is bad for voter registrants and voter registrars and encourages voter challenges that are frivolous, and we oppose it. Thanks.
Thank you, ma'am, for your testimony. Members, any questions? Thank you, ma'am, very much. Chair calls Bonnie Seelig, representing herself. Hello, ma'am. We show you registered as Bonnie Seelig. You are representing yourself, and you are here to testify for the bill.
Yes,
Okay, thanks for being here. You may proceed.
thank you. I contacted Travis County Voter Registrar Bruce Alfant, his Assistant Director Chris Davis last summer, asking about the procedure for submitting voters that I would be challenging on the Travis County voter rolls. He asked, how did I find the information? I replied through Catherine Engelbrett, True the Vote. This organization used various sources to identify voters who no longer resided in Texas. We're not talking about citizenship status. We're talking about dead people or alive people or people who changed their address. They filled out permanent address changes from the post office. These databases were looked through by True the Vote, and we came up with a list. Concerning the permanent moves, he asked me if I had seen them move or knocked on their door. And if I didn't, he looked at me and he said, I'm not compelled to look at your list. Well, personal knowledge is defined in Texas courts to include information based on one's observations or experience and include logical conclusions based on underlying facts and knowledge derived from various sources, including government databases. The problem is that we have enough laws and rules, but no one checking that the rules are being followed, nor the power to enforce those laws. Christine Atkins, in 2 summer meetings this past year, in 24, before the House and Senate, said that she had limited authority over county voter registrars. Well, now what? She has 5 of the largest counties, Bexar, Tarrant, Dallas, Harris, and Travis, contracting out their voter roll issues, and rather than joining the team system of the SOS. You might have great laws, but they are worthless if employees are not following the official guidance. This bill says it will put teeth in the rules, but you must have direct oversight, not rely on citizen complaints.
Thank you, ma'am, very much for your testimony. Members, any questions? Thank you, ma'am, very much for being here.
Okay, thank you.
Chair calls Catherine Cano, representing herself. Hello, ma'am. I show you registered as Catherine Cano. You're representing yourself, and you are here to testify against the bill.
Yes.
Okay, welcome. You may proceed.
I don't think this bill is necessary. voter registrars are already doing their job. They're faced with overwhelming amounts of frivolous and repetitive complaints because what some of these radical activists do is they just compile lists, and then when they don't get the results they want, or they don't know what the results of that complaint are, they file them again. But if the challenge is about residents, there's no hearing required. So you don't necessarily know that registration was investigated and found to be valid. I think this is unnecessarily punishing, and also it is going to hurt the ability of voter registrars, elections offices to do their job because they are going to be overwhelmed with and trying to prioritize things at the cost of other tasks. It's going to require, so voter registration challenges require an immense amount of research, which requires staff, which requires money. So if you're then taking away money from the voter registrar that they would use to fund this research and staff and time, how are they expected to do their jobs?
Thank you, ma'am. Members, any questions? Thank you, ma'am, for being here. Chair calls Ed Johnson, Harris County Ballot Security and Self. Hello, sir. I show you registered as Ed Johnson. You're representing Harris County Ballot Security and yourself, and you're here to testify for the bill.
That is correct.
Thank you, sir. You may proceed.
Okay. So just to start with, the challenge that was done in Harris County by Alan Vera, they took the national change of address list from the U.S. Post Office, found people that had moved and no longer lived in Harris County, and then actually had teams of volunteers that went out and verified that this information was correct. Over 100,000 we're talking about here, not just a few, and then submitted them to the voter registrar, where they have done absolutely nothing about cleaning up the voter roll. There's 100,000 people on the Harris County voter roll that do not live where they're registered to vote. It's bad for the voter, because if they actually went to try to vote, they wouldn't be able to vote where they are now because the registration's back at their old location. This helps clean up the voter roll. It helps the voter, so when they do go to vote, they're registered in the right location. The other one that they did is we cleaned the voter roll for death with the Secretary of State, but they just get records from the state and Social Security. If you die in another state, you're actually on that state's, you may have been a Texas resident, but you're on that state's death records. So we actually cleaned that up, found where there were dead people, submitted those, nothing. Those are where the challenges come in from. This section of the election code y'all should really look at reviewing, because it incentivizes, the Chapter 19 funding incentivizes election administrators for doing this and not doing their work, because they actually get paid for having voters on the voter roll. Taking them off loses their funding. So there is incentive for them not to do it. This bill would actually give them incentive for doing their job. We're talking about they just need to do their job by they're going to hold that fund from them being able to access that fund that they're doing, so that they do clean up the voter roll. They do abide by the National Voter Registration Act here. So this would be a very important bill to reverse that trend of, oh, let's just keep everybody on the voter roll because we get paid more. If you don't give them the money, then they're going to have to do their job and clean it up.
Members, any questions? Ms. Swanson?
Thank you, Mr. Chairman. I really appreciate you bringing your expertise on this, and it's just been horrible to hear from so many different people what's gone on in Harris County. I had people I know that worked on these very projects and worked on more recent projects, and we cannot get the voter registrar to do anything about it, and it's wrong, and we really, really need to pass this bill. So thank you for coming to testify.
Correct. It's a big help to the voter to have the voter roll cleaned up. If they're not registered in the county where Representative Busey, it helps your issue that you are trying on the limited ballot. If we get them registered in the right county, when they show up on election day, they won't have to vote a limited ballot. This really helps.
Members, any other questions? Thank you, Mr. Johnson.
Thank you.
Chair calls Andrew Hendrickson with the ACLU of Texas. Welcome back, sir. I show you registered as Andrew Hendrickson. You are representing the ACLU of Texas, and you're here to testify against the bill.
That's correct. Registering after Veronica and Emily will often leave me with very few points left to make since we tend to agree on things. But I will just point out that I think a lot of the testimony we've heard here about the challenges in Harris County and about the personal knowledge requirement kind of highlight what the problem I see in this bill is. If someone believes that the voter registrar is wrong and they are not fulfilling their duties under the personal knowledge requirement, again, the courts are the proper venue for which a determination about whether they're following the law or not, in which both sides can be heard, have a chance to be adjudicated in front of a neutral arbiter. That's where that should play out. If they are not, if there is actually personal knowledge and they are not following the law, that can be potentially the subject of a court case. What I don't think should be happening is having the Secretary of State using financial coercion to make them have a determination about what the personal knowledge requirement actually is. If the Secretary of State doesn't believe they're in compliance with the personal knowledge requirement, they can release an advisory opinion, but those are not binding on election officials. Those are advisory opinions. We like when people follow them. They tend to be correct. But you know, I think as far as this goes, if a local voter registrar, especially one who's been inundated with hundreds of thousands of challenges, feels as though those were not actually based on personal knowledge, and someone feels that that's wrong, then the proper place to play that out is in court and not by trying to get the county to comply with that person's view, which may be shared by the Secretary of State, view of whether the personal knowledge requirement was met by withholding funds rather than getting a judicial review of whether or not that standard was met. Thank you.
Members, any any questions for the witnesses? Thank you, sir, very much for being here.
Thank you.
Is there anyone else who wishes to testify on, for, or against House Bill 1478? If not, the chair recognizes Mr. Kane to close on the bill.
Members, any questions before I close?
Ms. Swanson.
I just want to say, great bill, and thank you for bringing this.
That's kind. Yes, ma'am. Our members, with that, I close and request your favorable consideration.
If there's no objection, the bill will be left pending. Is there objection? The chair hears none. The bill is left pending. Chair lays out House Bill 817 and recognizes Mr. Kane to explain the bill.
Thank you, Chairman, Vice Chair. Members, House Bill 817, simple bill, seeks to clarify the meaning of the word majority vote by prohibiting ranked choice voting, aka RCV, in elections for public office. There have been some disputes regarding whether the words majority vote in the election code authorizes preferential voting, also known as instant runoff or alternative voting in elections requiring a majority of votes cast for a candidate to win. Advisory opinions issued by the Secretary of State and the Attorney General, relying on the elections code language, legislative action and court opinions have concluded that Texas law doesn't permit it. However, since opinions by the Secretary of State and the Attorney General lack the force of law, House Bill 817 formalizes these opinions in the statute by clarifying that a majority vote to be elected to office means a candidate must receive more than half of the votes originally cast, and prohibiting the use of preferential voting systems in elections for public office. The bill is essential for ensuring the will of the people is accurately reflected in the outcomes of our elections. By removing that ambiguity from the majority vote, by explicitly prohibiting ranked choice voting systems in elections for public office, we can avoid future confusion or disputes regarding the use of RCV methods. For example, while the Republican Party of Texas platform calls for direct prohibition on all types of preferential ranked choice voting systems in all elections, and while some prominent Republicans like Senator Cruz and Cornyn have opposed it, so have prominent Democrats. In 2016, then California Governor Jerry Brown vetoed a bill that sought to expand ranked choice voting in the state, saying that it deprives voters of genuinely informed choices. In fact, in 2019, Governor Gavin Newsom vetoed the California Legislature's attempt to institute ranked choice voting for general law cities, counties, and school districts. To quote Governor Gavin Newsom, ranked choice is an experiment that has been tried in several charter cities in California where it's been implemented. I'm concerned that it has often led to voter confusion, and the promise that ranked choice voting leads to greater democracy is not necessarily fulfilled. If these governors oppose ranked choice voting, there must be serious grounds for skepticism. In conclusion, I urge this committee to support House Bill 817. Together, we can ensure that our electoral system remains fair and transparent. With that, I'm open to any questions. Otherwise, I'd like to come back and close.
Vice Chair Busey.
Thank you, Mr. Chairman. I gotta tell you, if you like Gavin Newsom's ideas, we can come up with some more bills to work on together.
Let's do it. Well, you know, I'm glad I got your vote on this one.
Let me ask you, are we having an issue with ranked choice voting somewhere in Texas?
For example, so, you know, the city that we're in has played around with it and amended their charter to do so. Last year, the City of Dallas's Charter Review Commission voted 8-6 to support making ranked choice voting, put it on their charter amendment. So really, frankly, let's just clarify it. If we've learned one thing from elections is speed and time really matter. If there's a problem, it's almost impossible to stop it. All right, we can't go backwards. And so to make sure that this is not allowed and to just lay it to rest so that none of these cities try it or keep trying, we might as well just very clarify that our law does not allow it. And so that's why.
So you think it's not allowed, but you want to come back and pass legislation to make sure it's not allowed?
Mr. Busey, if you could ask the city of Austin
No,
why on earth they still passed a charter ordinance allowing it to happen if they didn't think it was legal, why the city of Dallas was still trying to do it if it was
Have they done
illegal.
it?
We could save the taxpayers a lot of money by them not even trying to do that. So
Well,
that's the idea, Mr.
I'm
Busey.
glad you bring that up, because there's a study from 2022 that we spent $7.4 million on runoffs here in Texas. Ranked choice voting could have taken that cost out. I'm just wondering why we would want to take away a cost-saving initiative that still allows the majority to be elected properly.
Mr. Busey,
so
I
like
thought
to
you were
save
going to agree
taxpayer
with
money,
me
I'm
and
just
Gavin
curious why
Newsom that we
would not
should
wanna
ban
do that.
this. I thought we were on the same side.
I don't
with
usually
Gavin.
take a California approach to our Texas
Okay,
bills.
fair. All right.
So I'm just, why do you feel that a system that could save taxpayer money is a bad system?
You know, money's one thing, but ensuring the integrity of our elections is another. And when people go into that voting booth and vote for the person with the most votes, they're expecting that person to win. And in many instances, that's not the case. And I think we've got some people here probably answer some of those questions and give you some more details.
I guess I'm asking, so you think the voters can't understand ranked choice voting?
From what I can tell, the numbers are pretty clear that it leads to massive amounts of voter confusion. I just read some quotes to you on that.
Let me ask you this. Do you believe in local control and
No,
local
sir.
decision? You don't?
Not really, no.
Not
I believe the
usually.
state.
So you don't think Deer Park
cities-
should have the option
No.
to
not
do
at
this
all.
if they want to save
No.
your taxpayers' money,
No, sir. Those voters elected me to this body, sir.
to override their city council?
Absolutely. They are
Okay.
creatures of the state, yes.
I appreciate your conviction on that. I don't share it. And,
fine.
Mr. Chairman, this is a bill that's trying to stop something that's not allowed in the state of Texas, that doesn't happen. And honestly, if we pass this, DOJ is going to have to take this up next session and understand why we're doing government waste and passing bills on top of bills. So I don't understand what we're accomplishing by passing this bill to a problem that's not happening in the state of Texas. And
Yeah.
ultimately, if we went the other way
Yeah.
on this bill, and if we flip the intent, we could save taxpayer money, save time, and make sure that a majority is getting elected with higher participation. Because a lot of these runoffs happen with incredibly low participation in December or in an off time. And if we want more representative democracy, we should be looking at how to do that efficiently and do it where we save taxpayer money and get higher results. And so I just think this bill goes at the heart of those goals.
Chairman Busey, I'm hearing conflicting things from you. We're saying this is a waste of time because we're not doing it, but you want to do it somehow and save money. I mean, I would ask the taxpayers
Your
of
bill is-
Austin how much they spent
I'm saying
on
this
doing
bill
that-
is a waste of
how much
time.
they
I'm not
spent
saying
on
ranked
doing that
choice
charter
voting is a
amendment.
waste of time.
They spent a bunch of money on doing something that apparently may not be recognized in state law. So if we were to clarify it, maybe they would save those taxpayers a bunch of money and not wasted time doing charter amendments.
So
Neither
you
would
do
Dallas
or
any
you
other
don't
city.
want to save city?
We're going to save them
taxpayer
some
dollars.
money by clarifying the law that they can't do it so they don't waste their time doing it. Yes, sir.
Okay, well, I would like to actually save the $7.4 million that we spent on runoffs by doing something more efficient to help the people of Texas.
Thanks, sir.
Members, any other questions? Ms. Isaac?
Thank you, Mr. Chairman. Representative Kane, do we pass legislation every session to prevent cities, counties from doing things?
It seems to be the way these days. They're out of control, and we constantly have to do something to rein them in.
I
Yes.
know I did last session. Do we live in a republic or a democracy?
We live in a republic. Yes, ma'am.
Thank you.
Members, any other questions? Ms. Swanson?
Yes, I want to thank you for bringing this bill, Representative Kane. Years ago, when I first heard of ranked choice voting, the first thing, it sounded like a good idea. And we've seen many times in bills, especially in elections, that things that sound good are sometimes really, really bad. And I believe that about ranked choice voting, that it might sound good, but it's a disaster. And I have watched this happen around the country, and it really does prevent the people from electing who they want. And I do agree with you that we need to make sure that cities and counties are not passing something that we know it leads to results that are the opposite of what the majority wanted, and that's just wrong. So I really appreciate your bill, because this ranked choice voting is something we've got to stop. So thank you.
You, ma'am.
Members, any other questions? Thank you, Mr. Kane. We will proceed to testimony. The chair calls John Benura with the Texas Public Policy Foundation. Sir, welcome. I show you registered as John Benura with the Texas Public Policy Foundation, and you are here to testify for the bill.
That's correct.
Okay, sir. Thanks for being here. You may proceed.
Great. Well, good afternoon, Chairman Shaheen and members of the committee. Like it was stated earlier, my name is John Benura, and I'm a policy analyst with the Texas Public Policy Foundation. And I would like to thank you for the opportunity to speak in favor of HB 817. HB 817 is straightforward, uniform, and fair, unlike the practice of preferential or ranked choice voting. Preferential voting systems fail in 3 areas. First, due to ballot exhaustion, voters have been disenfranchised quite literally. If they only vote for one person when they go through this process, and that person does not make it past the first round, their votes no longer count. Quite literally, they're taken out of the final vote tally. Second, it is a slow and costly process. What we saw in a 2021 New York mayoral primary, there were a total of 9 rounds of preferential voting system ranked choice voting, and we ended up exhausting 140,000 ballots. 140,000 people's votes were removed from the final voting tally because of this process. And they just ended up with the same results as the first round anyway. So if you talk about costs, you talk about doing the same thing over and over and over again while reaching the result that you had at the beginning. I feel like that's costly of time and money and actual voters being enfranchised. Third, preferential voting systems are incompatible with state law. This has been based off of a 2003 Attorney General opinion from then Attorney General Greg Abbott. He wrote GA 0025 when Austin first tried to introduce ranked choice voting. He reasoned that majority votes cast has to be the majority of the votes cast before ballots are removed from due to ranked choice voting. So ranked choice voting does not comport with majority rule here in our state. He also reasons that it violates the election code because of the instant runoff part, where it's up to specific members of government to actually set a runoff date if there needs to be one. And finally, because Texas state law in this area preempts local municipality law, even if a municipality was to try to enact this law would be preempted by the state election code. But even with that all happening, we do see cities still trying to advocate for it, still trying to pass it. So as said before, we need to be able to have it codified and clear that ranked choice voting cannot happen in Texas. Thank you.
Members, any questions? Thank you, sir, for being here. Chair calls Andrew Eller with the State Republican Executive committeeman, SD 24, and yourself. Hello, sir.
Hello.
I show you registered as Andrew Eller, and you are representing the State Republican Executive Committeeman, SD 24, and yourself, and you are here to testify for the bill.
That is correct. Yes,
Okay,
sir.
welcome, and you may proceed.
Okay, I'm not going to reiterate what Representative Kane and the policy analyst from TPPF talked about, because they did bring up some very interesting pieces. But I will point out that Governor Greg Abbott, but when he was Attorney General, his opinion of GA 0025, it is very clear in Section 275.002, a majority vote is required in municipal elections for cities of over 200,000 in population. The exact wording is receive a majority vote of the total number of votes received by all candidates for the office. That in and itself, by that wording, would make ranked choice voting or preferential voting or instant runoff, whatever you want to call it, illegal for cities of over 200,000. It does not specifically state anything about statewide, county races, district races, smaller cities. So codifying this for banning ranked choice voting is essential, and that's why this bill, and I really appreciate Representative Kane bringing this forward, needs to happen. A couple of things about ranked choice voting that most people don't realize is that, first of all, it really disenfranchises what we call vulnerable voters, and those vulnerable voters are those who are disabled, typically the military, because they don't have time to fix a ballot. If they fill out the ballot incorrectly and send it in, or if they fill out the ballot incorrectly and then they need to try to fix it, that's a little bit harder to do. Also, a lot of the mail ballots, that's harder to do with ranked choice voting. So it disenfranchises all of our vulnerable voters out there. The other thing is it forces people to vote for candidates that they absolutely do not support. And then we did hear the testimony that it basically creates exhaustion on ballots. If you don't vote properly on your ballot, or you don't vote for a candidate because you don't like them somewhere in that ranking, your ballot will be tossed out somewhere in the rounds of voting. So that does happen. And so in the end, it's actually just a form of voter suppression, and there is no transparency in how these votes are counted, because it is extremely hard to do. Just a couple of real quick comments. The policy analyst talked about New York City, what happened there with 141,000 ballots being tossed out. In Sandy, Utah, in the mayoral race, it was only decided by 21 votes after more than 18% of the original ballots. 4,000 ballots were tossed or trashed because they were improperly cast, or because the folks lost their, they didn't have the rankings in there. It's happened in Maine, it happened in Alaska, Oakland, California, as well as Arlington, Virginia. I also would like to point out that this appears to be a refile of HB 3611 from last session, and Representative Eddie Morales sat right over here and actually talked about how hard it is to get his voters to vote properly in an election, and so an RCV type election would create problems for his folks.
Thank you, sir. Members, any questions? Thank you, sir, for being here today. Chair calls Joni Richards, representing herself. Oh, yes, you're right. Hello, ma'am. I show you registered, actually it's Joanne Richards, and you are representing yourself, and you are here to testify against the bill?
Correct.
Okay, well, welcome, ma'am. You may proceed.
Thank you very much. So rather than prohibiting preferential voting in all situations, consider that there are reasons why Republicans and Democrats in many states use ranked choice voting in some form and in some context. And I will mention 4 of them that I think that are appropriate here. Most share the belief that those who serve our country overseas, whether it be active duty and their families, missionaries, Peace Corps volunteers like myself, foreign service members and others, should have their voice heard in elections. Runoff elections are a problem for these folks. By the time the runoff ballot has been made through the round trip overseas and back, the runoff deadline has often passed, and the voter then is disenfranchised. There is a solution. 6 southern states use ranked choice voting. Alabama, Arkansas, Georgia, Louisiana, Mississippi, and South Carolina. They use ranked choice voting to solve this problem for overseas voters. The way they do this is that each overseas voter gets 2 ballots, one traditional ballot and one ranked choice ballot. They fill them both out. They return them both at the same time. If there is, the traditional ballot is open first. If there is no runoff election, the ranked choice ballot is stored like all other old ballots are stored. If there is a runoff election, then that ranked choice voting ballot is then opened, and their choice then, the highest choice of the candidates that remain on the ballot can be counted, and so their voices is heard. In the November 5th, 2024 election, for nonpartisan, if you will, candidates ran for the mayor of Baytown. Just under 19,000 people cast a vote for the mayor. That was just under 50% of Baytown's registered voters. Because no candidate received a majority of 50% or more, the top 2 candidates, Brandon Capetillo and Charles Johnson, who received 33% and 27% of the vote respectively, advanced to the December runoff. Only 2,110 voters voted, a dismal 5% of registered voters, yet the election was run by Mr. Capetillo, won with, quote, a majority of voters. With ranked choice voting or instant runoff voting, the winner would have reflected the preference of the 19,000 voters rather than the 2,000 voters who actually voted. Let municipalities adopt preferential voting in their nonpartisan elections. It saves money, reflects and supports a large majority of the electorate.
Ma'am,
There
I
are 2 other
apologize.
situations.
I apologize for interrupting you. We're trying to limit everybody's testimony to 3 minutes to give everybody the opportunity.
Sure, I understand.
Did you
I've
wanna,
got
like,
about 2 more
finish?
sentences left.
2 sentences would be great.
Super.
Thank you.
So special elections, primary elections are the other 2 examples. Preferential voting is completely consistent with a requirement for election integrity in that these ballots can be audited. Risk-limiting audits have been performed, and they are performed by the Ranked Choice Voting Resource Center. Instant runoff voting won't fix all of our problems. It may fix some of our problems. And so we ask that you oppose 817.
I
Sorry.
counted 6 sentences, ma'am.
Excuse me?
Hold on one second. I'm just teasing you, by the way. Members, any questions? Thank you, ma'am, for being here. We
You're very
appreciate
welcome.
you.
I appreciate it.
Chair calls Cynthia Griffin with the League of Women Voters, Texas. Hello, ma'am. I show you registered as Cynthia Griffin. You are representing the League of Women Voters, Texas, and you are here to testify against the bill.
Yes, sir.
Thank you, ma'am. You may proceed.
Good morning, good afternoon, Chair Shaheen and members of the committee. My name is Cynthia Griffin, and I'm testifying as a member and on behalf of the League of Women Voters of Texas in opposition of House Bill 817. We appreciate the opportunity to appear before you, and thank you for allowing us to share the League's position on this bill. The League of Women Voters supports election systems for elected offices in single-seat elections that require the winner to receive a majority of the votes, as long as the majority is achieved by instant runoff, ranked choice voting, or other forms of preferential voting, rather than holding a second separate runoff election. As reported in Pew's State Line in November of 2001, ranked choice voting encourages voter participation and voter engagement, promotes sincere voting over strategic voting, encourages more positive campaigning since candidates aim for a wider appeal, and avoids costly runoffs and ensures that winners in crowded races earn majority support. The Texas League opposes 817 because it bans preferential voting in all Texas elections. We believe that there are certain instances where preferential voting is beneficial for military and other overseas voters who do not receive and cannot return a runoff ballot in time, in special elections when it's beneficial to avoid a runoff to minimize the gap in representation, and in nonpartisan municipal elections to avoid very costly and low turnout runoff elections. Within the past few years, the preferential voting has been used successfully in several municipal elections across the country. For these reasons, the League of Women Voters opposes 817 and asks you to vote against this bill. And we thank you for your consideration.
Members, any questions? Thank you, ma'am, very much for being
Thank
here
you.
to testify. Chair calls Catherine Cano, representing herself. Hello, ma'am. I show you registered as Catherine Cano. You're representing yourself, and you're here to testify against the bill.
Yes.
Thank you for being here, and you may proceed.
Okay, I just want to give you some quick numbers based on the last Tarrant County runoff. Our last runoff, we had 378 voters, which is a 3.82% turnout. For that election, we had to run a whole election. That includes the polling locations, that includes early voting, that includes ballot by mail, that includes all of the election staff, that includes a public test, that includes the ballot board and the central counting station. I don't know how much that costs, but it's not an insignificant amount of money. Additionally, in that runoff election, in the general, the candidate who received the most amount of votes in the general election was about 40%. The second candidate was about 39%, and the third candidate was about 20%. However, in the runoff, the candidate who received the 39% won that election with 85% of the vote, whereas the candidate who received 40% of the vote, just slightly more, lost that election with only 14% of the vote. I ask you if that actually reflects what the majority of voters in the initial election wanted. In the general election, 52% of the population turned out to vote. Again, in the runoff, only 3.82% turned out. It's also true that runoff elections make it much more difficult for people who vote by mail, including our military voters, to participate just due to the time it takes to get a ballot to them and then back from them overseas with the reduced timeline of a runoff election versus a general election. I do believe in representative government. I do believe in local control. I think entities that want to use ranked choice voting to avoid runoffs should be allowed to do so. But if the Texas Election Code already prohibits ranked choice voting or preferential voting, then why are we here? Why are we listening to a bill that's just going to say, yep, that's correct? We've just wasted all of our time. We've just paid all of you to sit here and listen to a bill that is already addressed under Texas law.
Members, any questions? Thank you, ma'am, very much for being here. Chair calls Kevin Hale with the Libertarian Party of Texas and self. Welcome back, sir. I show you registered as Kevin Hale. You're representing the Libertarian Party of Texas and yourself, and you are here to testify against the bill.
That is correct.
Okay, thanks. You may proceed.
Thank you, Chairman Shaheen, Vice Chair Busey, and the rest of the members. I want to talk to you again as a candidate. Our number one opponent is apathy. 60% of the voting age people in Congressional District 32 are not participating. We need to find ways to empower them to get engaged again. This bill goes backwards. It does not allow them to have a voice. So the Libertarian Party of Texas opposes House Bill 817, which prohibits the use of preferential voting systems. We want to promote fair and representative outcomes. Preferential voting systems give voters the opportunity to rank candidates in order of preference, allowing for more nuanced expression of voter intent. These systems have been shown to produce outcomes that better reflect the preference of a broader share of the electorate. LP Texas has been using approval voting since 2018, including none of the above. So it can work, and it can easily work, and it has been working. This gives voters a reason to come out and actually participate. They're not participating right now. Like I said, 60% of the voting age people in my congressional district are not participating. So this would, if we had ranked choice voting, I think that would make it possible for those people to come out and say, I really like, this guy right here, but this lady right here and this other one, I want them a little bit lower. So I think if we had this, we would be able to get a broader electorate to show up, and we'd also get a better view of what they actually want. And with that, I'll take any questions.
Members, any questions? Thank you, sir, very much for
I
being here.
appreciate you
It's
guys.
helpful.
Y'all have a great day.
You too. Chair calls Ed Johnson, Harris County Ballot Security and Self. Hello, sir. I show you registered as Ed Johnson, and you are representing Harris County Ballot Security and yourself, and you are here to testify for the bill.
That is correct.
All right. Thank you, sir. Welcome back. And you
Okay, start with, we're hearing a lot about overseas military voters and not getting a chance to vote. Well, first of all, ballots for overseas are sent out 45 days before the election. They actually have more time to vote than local people, and they get it quicker because ballots are emailed to them overseas. They get it that day, and then they have to print it out and return it. And we have 5 days after the end of the election for the mail to come back in. There is no problem with overseas voting and them getting the opportunity to vote in a runoff election. They probably have more time than anybody else in the system right now. Ranked choice voting, if you heard that Gavin Newsom wasn't against it, actually was created by California and Los Angeles. And that city tried to do this, and they quickly realized that you can manipulate the outcome of the election by the number of candidates and things that you put in the election, and you will end up electing somebody that doesn't get 50% of the vote. And it's we have other cities here in the state that are trying to do this. You've heard them all talk about how they want to do this. We need to put a hole in this, put it in the law where it's very clear that it's not allowed. And Representative Busey's not here, and he's talking about this great expense. Right now, our election equipment in Texas does not support ranked choice voting. You would have to get new election equipment. You talk about a cost. We're talking billions, not a couple of thousand. So this is a good bill. It clarifies the law so that cities don't waste time and money trying to get new election equipment and put something in that's currently not real clear in the law of what it does.
members, any questions? Ms. Swanson?
Yes. Thank you, Mr. Johnson, for bringing up these really important points, and I'm very sorry that some of our members were not here to hear them.
Hopefully you can hear us in the back room on the mic.
Unfortunately, no. I don't know why we do. Maybe, I would really like to hear some of those points again because I think we didn't really quite catch them really well. Could you kind of clarify those points?
I would be more than happy to clarify my last statement of cost in the elections. Currently, Representative Busey, our election equipment doesn't support ranked choice voting. So to do ranked choice voting, you would have to get new election equipment. And that's very, very expensive. We're talking probably in the billions of dollars to do that. So to switch to a ranked choice system would do it. And I hate to see cities waste their money and time doing this when it's not in the code and our equipment won't support it. Hand ballots are even more confusing.
Members, any other questions? Thank you, Mr. Johnson.
Thank you.
Chair calls Kevin Hale with the, or I'm sorry, the chair does not call Kevin Hale. The chair calls David Como, representing instant runoff voting for Texas and self. Thank you, sir, and welcome. I show you registered as David Como, and you are representing instant runoff voting for Texas and yourself, and you are here to testify against the bill.
That's right.
Okay, thank you, sir. You may proceed.
I'm David Como. I live in Houston. I'm the chairman of Instant Runoff Voting for Texas, and I'm testifying against 817. It would completely prohibit in all cases the option, which is what we support, opening up the option to use instant runoff voting in certain elections. I'm not going to repeat a lot of the things that we've already heard against the bill. I think we can clarify a few things. With respect Vice Chair Busey, I don't think you captured the taxpayer savings appropriately. Texas spends a little over $7 million, it's my understanding, on runoff elections. But every county then also has to spend, and Harris County alone spent $7.2 million in the first two runoff elections they had in 2004. That doesn't count the Baytown race that we heard about earlier. We've heard about ballot exhaustion. And it's correct that a person who can get to a point where their vote doesn't count, but ballot exhaustion is a lot less, if you call it disenfranchising that, than runoff elections where significantly fewer people go. That's a different kind of disenfranchising when people aren't voting at all. There was a statement that isn't, there are a couple statements that I don't think are accurate. First of all, instant runoff voting does not require a voter to vote for every single candidate. In fact, I would argue if you don't like a candidate, you should not put them down. If you're permitted, for example, 3 votes, you can vote for only 1 and 2. Then your third preference wouldn't be there, but not voting at all is just like on our current ballot. If you don't vote for somebody, you're voting for the other person. There was also a statement made that we would need completely new election equipment, and that's not correct. It's my understanding there are 2 basic kinds of election equipment that we have throughout the state. Both kinds of election equipment do support instant runoff voting, so that is available. Also, it saves time, and I don't think there's been a lot of emphasis on the time that it saves. Right now, according to the Senate State Affairs Committee interim report, it's about 95 days on average between a primary initial election and a primary runoff election. South Carolina does that in 14 days. How do they do that in 14 days? Because they allow instant runoff voting for military and overseas ballots. So the first time they vote, they've got their preferences for their backups if they need it, and so they can get those runoffs conducted in 14 days. So with that, I'll go ahead and close. We're against 817. Like others have said, we don't really think it's something y'all need to take up because the current election code says what it says. But if you were to take it up, I would consider it's an option that should remain in the toolkit.
Members, any questions? Ms. Swanson?
Yes, thank you for coming.
Yes, ma'am.
As someone who's also from Harris County, I'm interested. I have never heard of the instant runoff voting for Texas, and I would like to ask who funds you and funds this, if it's an actual organization.
It's an actual organization, and we're mostly funded by, I mean, I've got my wallet in my back pocket. It's a little lighter than it was a few months ago. We don't have, we have a C3 where all of our donors are made public. I can tell you that we are grassroots, and we're running on fumes.
So who are your major donors?
I don't know that I'm in a position right now because I don't have a list in front of me, but I'm not sure that all of our major donors would necessarily want to be made public because they're charitable endeavors. But I don't know how to answer that question better, ma'am.
I thought you just said that these things, that your funds are public. So why would you not give us that public information?
We have 2 separate organizations, ma'am. We've got a C3, which provides for our social media to help educate the public to do that kind of thing, and we do pay for a C4, just like I think a lot of folks up here may have. I don't know. But
so with your organization that does have to file reports, who would be your major donors on there?
I can't tell you off the top of my head. I can send you a list later on if you would like to have a list of our 501c3.
Are you a volunteer or are you being paid?
I'm a volunteer.
Okay.
I paid for my own travel.
Okay. All right. Okay. Thank you.
Yes, ma'am.
Any other questions, members? Thank you, sir, for being here today. We appreciate you.
Thank you very much.
Chair calls Scott Turner with representing Eternal Vigilance Action Inc. and self. Welcome, sir. I show you registered as Scott Turner. You are representing Eternal Vigilance Action, Inc. and yourself, and you are here to testify against the bill?
Yes, Chairman.
Okay, well, welcome. You may proceed.
Thank you. Thank you, Chairman. Thank you, members of the committee, for this opportunity. My name is Scott Turner. I'm a retired member of the Georgia House of Representatives. Served 8 years with a primary focus on elections, so this meeting felt very familiar to me. And also it felt really familiar because about 15 years ago, I sounded just like Representative Swanson. And I mean, almost word for word, some of the same things that Representative Swanson has said today, I have said in the past, because I was a ranked choice voting, instant runoff, preferential voting skeptic. But I also got elected in a special election runoff where the turnout in the second round was equal to my first round turnout. And I began searching for a solution to our runoff problem in Georgia. And because I was very prideful in my work, I like to base my decision-making on the evidence. And even though I was a skeptic of RCV, there were other conservatives who told me that maybe this is something you should dig more into, because what I found over time is that the criticisms of ranked choice voting, instant runoffs, fall into two buckets. The first and the largest bucket, and some of the arguments you've heard today, are demonstrably false statements. And I don't blame people for believing that, because they get proliferated in a major way, and you end up thinking that that's the only way it is, or because the case studies that they point to are sort of cherry-picked to present it in the most disfavorable light. The second bucket that people use to criticize ranked choice voting are technically true, but not really ranked choice voting's fault. And you've heard some of the things mentioned today, like the length of time in New York City. New York City has a ballot law that requires that they don't do pre-processing, that they have to wait until a week after the election before they can begin processing all their ballots. It causes delays. Similar situation in Alaska, their geography requires them to have a similar law in their books. It delays the results. These are not ranked choice voting problems. Without ranked choice voting in those areas, they would still have those problems. So when I began to dig into the facts, what ended up happening was the conservatives in Georgia saw it as a solution to our runoff problem, and we passed it. Every Republican in Georgia voted for ranked choice voting as part of SB 202. If you recall, that was the bill that Joe Biden labeled Jim Crow 2.0. But our own governor labeled it the Easy to Vote, Hard to Cheat Act. And we've been able to reduce our time of our runoffs from 2 months to 1. So we're no longer watching political ads during the SEC championship game. Welcome to Longhorns, to the SEC, by the way. Another thing to keep in mind is this is not a confusing thing. 14 million Americans, this is what I'm talking about when they cherry pick things. 14 million Americans today get to use some sort of ranked choice ballot election. You don't hear about all the ones that went well. You hear about the problems. And one of those problems happened in Alameda, where a human error in the programming of the machines caused a wrong voter to be announced. And, but we had a similar instance in Georgia. I'd be happy to tell you. To finish up, my organization, myself, I would just challenge you to be a little more curious about ranked choice voting, and we'd offer ourselves up as a resource so that you could hear the whole story about any question you may have. Thank you.
Vice Chair Busey?
Can you tell your example that you wanted to share?
Sure. So in DeKalb County in 2022, which is the second largest populous county in Georgia, we had a county commission race where the candidate went into the polling place, voted for herself. That night, when they pulled the tapes, she had 0 votes in that voting precinct. We used many machines in all of our elections in Georgia. It was not a ranked choice election. It was a similar type of error that happened in Alameda. The programming of the machine was done incorrectly. One of the folks who testified earlier said there's no transparency in ranked choice voting. Well, the cast vote record is made public. And in California, they don't have a post-election audit process like we do in Georgia and several other states, so they didn't catch it. But when they published the cast vote record, an individual that works at a voting rights organization was the one who caught it because it was that transparent. She's the one that notified. She didn't even live in California. She just had an interest in the results of the election. So she went and reran the election and realized in the software that there was a problem. And she notified the clerk, and they were able to make sure they're the correct winner. In Georgia, we didn't have that problem because our post-election audit process caught it, in addition to the fact that the candidate herself saw that she had 0 votes when she knew she voted for herself. So those types of mistakes are not based on ranked choice voting. It's a human error that can occur, whether it's ranked choice voting or not, anytime you're dealing with technology. That's why voting methodology is sort of independent of voting process. And from end to end, from the voter registration cleanup to the voter experience, to the audit process on the back end, you have to have a really cohesive process regardless of the methodology that you employ.
Members, any other questions?
Yes.
Ms. Swanson?
Yes. Thank you, Mr. Chairman. I'm interested again, since I try to keep up with the different groups, but there are so many, it's impossible.
Sure.
I've not heard of Eternal Vigilance.
Don't blame you.
When was it started, and how large is the organization, and who are your major donors?
So Eternal Vigilance Action is made up of a group of former state lawmakers. I am a movement conservative, academics, and activists. We have 5 board members, 3 of which are former state lawmakers, all Republicans. We have an activist that works that is a former vice president at FreedomWorks. And we have a college professor that I had that also serves on the board that offers some academic and also HR support. Our donors are a group of patriots. There's too many to name. It's a vast network of folks who contribute to our work. Our mission is to advocate for policies which maximize the American promise of liberty and justice for all. We work on several different aspects of different policies. Elections is just one of them. We also do a great deal of professional licensing work, trying to remove barriers to economic opportunity for folks. We also do criminal justice reform work, where we shepherded legislation in Georgia that allows families of cold case murder victims to appeal or to ask for case reviews. That has led to the arrests of cases that murders that were 25 years old. So that's our group. That's the basis of it. I'm not surprised. We're not Texas-based, but as a movement conservative, anytime one of these issues comes up, it concerns me, because I'm trying to fix a significant problem in my own home state, and every time another Republican state takes up actions like these, it makes it harder for me to fix my own problems, and I have a significant problem.
So you still live in Georgia?
Yes, ma'am. I am a
Okay.
Georgian. Yes, ma'am.
Thank you.
Yes.
Members, any other questions? Thank you, sir, for.
Thank you, Chairman. Thank you, members of the committee.
Sir, we have a question about your registration real quick.
Sure.
So I just wanted to clarify, so the registration shows that you live in Holly Springs, Texas, but.
I'm sorry. It's supposed to be Georgia.
Oh, okay.
30142.
So is it okay if we
Yes.
change your
Absolutely. That was
registration
a
to be Georgia?
Clerical error, my fault. Right. Yep.
Okay. Chair calls Chris Saxman, representing himself.
Thank you, Mr. Chairman. I'd also like to change that registration to also fair vote.
Okay,
I can.
so give us 1 second
I
and
tried to
we'll
update
do
that.
that. Oh, I want to make sure I'm understanding. Do you want to change your registration to where you're supporting the
Fair-
bill?
No, in opposition to the bill, but the organization's Fair Vote and myself.
Okay, fair vote. All right, give us 1 second.
Thank you, Mr.
We'll-
Chairman.
We'll update. If the public wants to know why we're so careful about these, there's the rule, the House of Representatives has rules in place, and if we don't follow them succinctly, it can cause an issue with the legislation further down the process. So that's why, if you wonder why we're so focused on getting things right, that's why we go through this. All right, thank you, sir. So I show you registered as Chris Saxman. You are representing Fair Vote and yourself, and you are here to testify against the bill.
Yes, sir, Mr. Chairman.
Do you live in Richmond, Virginia?
Yes, sir, I do.
you
Not far south of Ashland.
Okay, there you go. I was going to call that out. Well, thank you. Welcome.
Well, I have a
And,
son that just graduated from there.
Really?
Yes, sir.
Okay, I went to school near Richmond.
And I
That's what we're
think
talking
you
about.
probably played football against many of my colleagues in WNL.
Oh.
Be gentle, please.
All right,
sir.
now we can.
But y'all beat us all the time.
We can have a
so it's
long
all right.
conversation now.
Look forward to
Welcome,
that.
sir. You may begin
Go
your
Jackets, right?
testimony.
Thank you, Mr. Chairman, members of the committee. As a former four-term Republican Virginia delegate who recently led Lieutenant Governor Winsome Sears' transition team in PAC, I'd like to share my experience with instant runoff, ranked choice voting, and its positive impact for Virginia Republicans. During my 2001 election to the Virginia House, Republicans dominated Virginia state politics with 2 U.S. senators, consecutive Republican governors and attorneys general, and a near supermajority in the House. Yet by 2020, our situation had dramatically changed. After the 2020 election, I called my Dave Rexroth, the executive director of the Republican Governors Association, and my former campaign manager. When I asked if RGA had budgeted money for the Virginia gubernatorial election, he revealed that they weren't planning to spend anything in Virginia, essentially conceding defeat for 2021. I suggested that losing in 21 would reduce us to a third-party status in our two-party system, with no chance of winning statewide elections again. David agreed, and he's from Waynesboro, Virginia. Simultaneously, the Republican Party of Virginia State Central Committee was deadlocked on choosing a nomination method for the 2021 statewide races. Their publicly live-streamed debates led to questions about the party's ability to govern effectively. The committee ultimately compromised on an unassembled convention using instant runoff or ranked choice voting, which the party had previously used in 2020 to elect its chairman. This decision transformed Virginia Republicans' fortunes. Ranked choice voting kept all candidates in the race as Republicans. One had threatened to run as an intentional independent spoiler candidate and actually encouraged more participation, ultimately fielding 17 statewide candidates who helped expand the party's base. Importantly, the format pushed candidates to focus on issues rather than negative campaigning. Glenn Youngkin secured the nomination, and the party quickly unified behind him due to minimal lingering campaign animosities. His favorable ratings climbed, prompting the Republican Governors Association to invest $15 million midsummer and take over the ground operations. The entire Republican ticket swept the top 3 statewide offices and regained the House of Delegates with a 7-seat pickup. Following this success, Republicans in Virginia used it, RCV, in 4 congressional district nominations in 2022 and a state house race in 23. The State Central Committee also voted 63-37 against a resolution banning RCV. In 2024, Mr. Chairman, the Republican National Committee used ranked choice voting for donation solicitation after passing a resolution against it. Also, Governor Ron DeSantis' super PAC used it to determine issue priorities and add messaging within the PAC. A successful political system, Mr. Chairman, requires healthy political parties. Ranked choice voting is a valuable electoral tool that Texas political parties could utilize should they choose to. Someday you might need it, just like Republicans in Virginia did.
Thank you, sir. Members, any questions? Welcome to Texas, sir.
It's great to be back.
Chair calls Elizabeth Miller, representing herself. Welcome, ma'am. I show you registered as Elizabeth Miller. You are here representing yourself, and you are here to testify against the bill.
Speaking, yes, that is absolutely correct. Thank you
All
for
right,
your
well, welcome.
time.
You may proceed.
I think alternative voting methods are very important. I think they're great. They allow voters an opportunity to express their will. I don't have time to convince you on all that today, probably, so that they're great. But I encourage you to keep your minds open and allow parties to have that tool. I guess what I would address are the objections I've been hearing. The assertion that it will prevent military members from participating in runoffs is actually the opposite of true, as a speaker explained earlier, and I encourage and challenge you to discuss that with more of the elections administrative type people. The allegation that our equipment can't count it is actually false, and again, I encourage you to contact your elections administration folks and ask them about that. As far as the chair said the other day in the Senate on a similar bill that these alternative voting methods have the potential to harm Democrats and Republicans. On that, I agree. I think you will not hear people up here asking you to eliminate this option. You won't hear from grassroots Republicans, grassroots Libertarians, grassroots Democrats, independents. The plurality of Texans are not the elites within either the Republicans or Democrats. Yes, banning these alternative methods helps you who are already in these seats. It helps the people in power in Republicans and Democrats, but it hurts real Texans. It bars them from expressing their will. And I respectfully don't see a reason for the author's bill to create, for the government to create a barrier that takes away that option from municipalities. So please oppose this bill. Thank you.
Thank you, ma'am. Members, any questions? Thank you, ma'am, for being here today. Is there anyone else who wishes to testify on, for, or against House Bill 817? If not, the chair recognizes Representative Kane to close on the bill.
Thank you, Sharon. Members, any questions? We'll swing it out. Try and be quick on it. It's pretty impressive that all of a sudden we've got people really concerned with cost. If anybody would like to, go to one-day voting, I support that. Worried about the cost of elections. But let's talk about who supports it. Tim Walz, Bernie Sanders, Communist Party of the United States of America, USA, Democratic Socialist of America. Who wants to ban ranked choice voting? Donald Trump, the Republican National Committee, the Republican platform of the RPT, which was created by conservative grassroots Texans. Since 2022, 13 states have done this. That'd be Alabama, Florida, Idaho, Kentucky, Louisiana, Mississippi. I may not read them for you, but let's go to Georgia real quick. Senate Bill 175, earlier this month, passed out of the Senate to ban ranked choice voting, and it's in the House, and it's expected to happen. There's a call and a push in Georgia now by the Republicans to ban it because they realize they did something wrong. With that, I close.
Thank you, Mr. Kane. Members, any questions?
Miss
Swanson, sorry.
Thank you, Chairman. Representative Kane, I just wanted to clarify one thing. You said you listed an impressive list of states, and you said they have done this. So they've done ranked choice voting, or they've passed bills to
Yes,
ban
ma'am.
it?
13 states since 2022 have prohibited ranked choice
Okay,
voting.
and what were those states?
Alabama, Florida, Idaho, Kentucky, Louisiana, Mississippi, Missouri, Montana, Oklahoma, South Dakota, Tennessee, West Virginia, and Wyoming. Look, and if we don't hurry up, Georgia's going to beat us to it. We can't have that.
Thank you.
Thank you.
I think we need to check, but I don't think that Georgia language has actually moved forward. I'm happy to check that offline, but I don't think.
You got
the
it.
fact
March
that was
4th,
correct.
it left the Senate, and yesterday the news reported grassroots conservative media were calling on people to call the Georgia House to move it out of the House.
To make some call. I think we have some Georgia specialists. I think we can ask on the fly, but I don't think that's accurate.
Thanks.
Thank you, Mr. Chairman.
Yep. Any other questions? Thank you, Mr. Kane. There's no objection. The bill will be left pending. Is there objection? The chair hears none. The bill is left pending.
Thank you.
Chair lays out House Bill 1661 and recognizes Representative Chairman Vasu to explain the bill.
Thank you, Mr. Chairman, members of the committee, for the opportunity to lay out House Bill 1661. As you may recall, during the, is that mic on?
Yes.
All right, good, good. I don't know, maybe it's just this room, I'm not hearing what I normally do. During the 2022 March primary in Harris County, so we've laid the groundwork. It's always Harris County. During the Harris County 22 March primary election, the ballot was so long that it required two 8.5 by 14 ballot pages for one ballot. 4 Republican polls received 8.5 by 11 ballot paper instead, suppressing the ability of voters to vote on an entire ballot. On November 8th, 2022, same county, the Harris County Elections Office did not provide a sufficient number of ballots to cover the same number of voters who voted in the last election plus 25% as required by the election code. Instead, over 120 polls were woefully undersupplied in ballot paper. It also was well documented before Election Day that ballot paper was jamming in the polls and extra paper was needed at every poll. Presiding judges were panicking and calling the EA's office, election administrator, but they could not get through the phone lines. Many presiding judges resorted to begging for paper for neighboring polls, and still close to 30 polls ran out of paper. Naturally, the polls ran out of paper in the afternoon when traffic is the worst in Harris County. Thousands were turned away from the polls on Election Day. The election administrator's office was notified of the problem through the Republican Party, yet when an emergency hearing was held to keep polls open for an additional hour, the election administrator did nothing to stop the process, even though they knew that the polls had run out of ballot paper. The lack of supplies was not limited to ballot paper. Numerous judges reported not having enough provisional ballot applications necessary for extending the polling hours and other essential forms to operate the polls. Preventing voters from voting is a serious crime, and thousands of voters are preventing from voting in Harris County. House Bill 1661 addresses this issue by increasing penalties for failure to distribute election supplies from a Class C misdemeanor to Class A misdemeanor, for obstructing the distribution of election supplies from a Class C misdemeanor to a state jail felony, and for releasing election results before the polls close on election night from a Class A misdemeanor to a state jail felony. The bill also creates 2 Class A misdemeanors for the authority responsible for procuring the election supplies for an election if the authority intentionally fails to provide an election precinct with the required number of ballots. Also, the authority responsible for procuring election supplies commits an offense if the authority intentionally fails to promptly supplement the distributed ballots upon request by a polling place. Now, you may know criminal law has mens rea, okay? The mens rea here is literally the highest, intentional. So someone has to intentionally violate the law to be subjected to these heightened criminal penalties. And if somebody is intentionally obstructing ballot supplies, is intentionally undersupplying their precincts with ballot paper, they ought to go to jail. Happy to answer any questions.
Members, any questions? Ms. Swanson.
Yes, thank you for bringing this bill. As someone who has been on this committee for my 5th term and lives in Harris County, it was really a nightmare when we could not get enough paper and in that general election, and it was wrong. Most of the polling places that did not have enough were out in Republican areas, mine being one of them. And I had a good number of places that ran out of paper. I do know, having personally talked to a lot of these election judges and alternate judges, they asked for more even before that day and were refused. I do want to say that we did away with that elections administrator with a bill Senator Betancourt and passed that came through this committee. But there were so many things to indicate that it must have been intentional. I know that Republican Party, when they couldn't get through for hours on end, sent a representative to the actual warehouse where they're kept to say, hey, are y'all not getting the information? Places are running out around the county, especially in the suburbs. And that elections administrator threatened that young man that if he didn't get off the property, that he would be arrested for trespass. There were no allegations he was doing anything wrong. They just did not want to hear about it. And I could just go on and on about how it must have been intentional, and I really appreciate your bill here.
You bet. Thank you.
Members, any other questions? Thank you, sir. We'll
bet.
recognize your right to close. Chair calls Veronica Warms with the Texas Civil Rights Project. Chair calls Kathy Hagler, representing herself. Ma'am, I show you registered as Kathy Hagler. You're representing yourself, and you are here to testify for the bill.
That's correct, Mr. Chairman.
Welcome. You may proceed.
Thank you, Mr. Chairman and members. We've all heard about Harris County 2022, and the best word I've got for it is nightmare. The organization that I was working for that day was receiving distress calls from judges and clerks all over Harris County early in the afternoon saying they were starting to run out of ballots or they were running out of ballots and they couldn't get more coming in. The calls got more frantic and came in more and more as the election day went on. The voter lines were getting unmanageable, and the voters were furious that they couldn't vote because they didn't have ballots. Voters who couldn't wait for the supplies to arrive just left and didn't vote. The county was not getting the election materials to the polling places fast enough. I did talk to someone who talked to someone else, so this is secondhand, who said that the drivers were leaving the warehouse or home base with the ballots that were needed, enough for one polling place, and they drive across the county to deliver to a polling place and drive all the way back to the warehouse to get some more to drive. And Harris County is a big place, y'all. It often takes more than an hour to get across the county. So that's what they were doing to deliver the ballots. One of the leaders in my organization started calling presiding judges and would match up a judge who had excess ballots at their polling place with another judge who didn't have any ballots, and they would process the paperwork to account for everything, and they would share ballots that way. And yet, I want to show you something. I should have made everybody a color picture, but this is a photo that one of the election judges sent to me that he didn't know that there was a shortage of ballots going on across the county because he hadn't talked to anyone all day. But on election night, he packed 30 cases of ballots into the back of his truck to return to the warehouse because that was how many excess ballots were delivered to his polling place. And he just had no idea that was going on all around him. That tells you about the inefficiency there. So House Bill 1661 takes the proper planning for and delivery of the election supplies very, very seriously, which I appreciate, and it adds that Class A misdemeanor and the state jail felony language to the law. I think it's a great bill, and this should never, ever happen again. Thank you.
Members, any questions? Thank you, ma'am, very much. Chair calls Catherine Cano, representing herself. Hello, ma'am. I show you registered as Catherine Cano. You're representing yourself, and you are here to testify for the bill.
Yes.
Okay, you may proceed.
Okay, so in general, I like this bill. I think that people who do intentionally obstruct supply distribution for an election and cause voters to not be able to vote should be punished by law. I am concerned about some of the language. I do appreciate the inclusion of intentionally in Section 2. I have concerns about promptly, and the reasons I have concerns about that is because there's a lot of things that can go wrong in an election, things that you try to plan for, but you can't always anticipate. And the ability of an elections department to respond to emergencies or requests by polling clerks is limited by the number of staff they have available. So fortunately in Tarrant County, we have several members of our warehouse distribution team that are able to respond sort of regionally. But what if you have a lot of requests coming in? Like we've heard, Harris County had tons and tons of requests from polling places coming in. What if you need to triage where things go? If you say, okay, you're gonna go here first and then there, is that an intentionally, like, it's not prompt, right? So would that be intentional? Like if you had to say, location A gets their ballots first, is that intentionally not helping or not promptly providing ballots to location B, right? So that's really my concern, is that what counts as intentional and what is promptly. But otherwise, yeah, I pretty much like this bill.
Members, any questions? Thank you, ma'am, very much for. Oh, Ms. Isaac.
I just want to make sure, you did say you were for the bill, though?
Yes, I am for it.
Okay.
I'm concerned about this language, like unintentional consequences of this language, where if someone has to prioritize a location over another location, would that be intentionally obstructing delivery to the second location, even though you can't do both at the same time?
Okay. So I think something would have to happen in order for someone to question someone about that, right? Like,
I know, but that's what I'm
right.
saying, unintentional consequences.
Okay.
Yeah.
Members, any other questions? Thank you, ma'am, very much for being here. Chair calls Ed Johnson, Harris County Ballot Security and Self. Hello, sir. I show you registered as Ed Johnson. You're representing Harris County Ballot Security and yourself, and you are here to testify for the bill.
That is correct.
All right, you may proceed. Thank you.
Okay, this is probably the worst, I guess, fragrant, denying people the right to vote I have ever seen in an election. I used to be the director of the Harris County Clerk's Office, and actually probably wrote all the software for all the equipment that they were using there, and had all the guidelines that they were following. They were supposed to start with, by the Secretary of State's rules or suggestions, supplying as much ballots as that polling location used the previous election. And they did not do it. They intentionally did not do it. The iPad system that you check in on, we actually had that real time back to the office. So we knew they knew exactly how many people were voting at every location, and the supply management, the distribution of supplies is computerized down there, and it's tied to the same system on a dashboard. And we actually did algorithms to predict when a polling location would be running out of supplies of ballots, statement of residence, provisional ballots. We knew the number. They knew the number that were each one of the locations. It's in the computer system. They had a count of how many people were voting at the location, and computer was telling them, hey, these people are going to run out, in the next 5 minutes, 10 minutes. And they ignored it. They completely ignored it and did not supply ballots to keep people from voting. They should all be in jail for this.
Members, any questions? Thank you, sir, for testifying.
Thank you.
Chair calls Andrew Hendrickson with ACLU of Texas. Okay, I think, hold on, is that everyone? Chair calls, Taylor Trevino with the Texas Civil Rights Project. Welcome, ma'am. I show you registered as Taylor Trevino. You are representing the Texas Civil Rights Project, and you are here to testify against the bill.
Yes.
Okay, thank you for being here. You may proceed.
Thanks. My name is Taylor Trevino. I'm the Voting Rights Senior Advocacy Manager at the Texas Civil Rights Project, here to testify against HB 1661. This bill adds to and increases the severity of a number of criminal penalties for election workers and officials. This measure will not make our elections more secure or run more efficiently. Texas counties are already struggling to adequately staff our elections with the resources the state provides. According to a report by the Bipartisan Policy Center, our election official turnover rate nationwide has grown from 28% in 2004 to 39% in 2022. In the 2024 election cycle, the turnover rate in Texas was about 40%. This turnover rate is causing a massive loss of institutional knowledge regarding election administration across our state, making the voting process more difficult for both voters and election officials. One of the primary reasons for this loss is because this legislature has relentlessly increased and criminalized the duties and responsibilities that election officials and workers are required to accomplish with the inadequate resources provided to them. Instead of adding yet more criminal penalties into the equation, this body should adequately fund elections so that counties have the resources and staffing necessary to quickly respond to any immediate changes or needs. We ask the committee not to report HB 1661 favorably. Thank you.
Members, any questions? Thank you, ma'am, very much for coming to testify. I'd like to call a resource witness, Ryan Jimenez with the Secretary of State's office. Sir, I show you registered as Ryan Jimenez. You are with the Texas Secretary of State's office, and you are neutral on the bill.
Yes, that's correct.
Thank you, sir. Chair Busey.
I don't know if you'll know, but has anyone been found guilty in Harris County of intentionally holding back paper?
Not that I'm aware of, sir. I'd be happy to have our office check back with you if someone else is, but I don't believe so.
We're just hearing a lot about people that need to be in jail, and I'm just curious who and where those cases and charges are, if that's happened. But I'm not aware of any either, but I just wanted to make sure.
Yeah, no, like I said, I'll have our office get back to you if we are.
I appreciate it. Thank you.
Members, any other questions? Thank you, sir, for coming up. We appreciate that. Is there anyone else who wishes to testify on, for, or against House Bill 1661? If not, the chair recognizes Chair Vasu to close on his bill.
Thank you, Mr. Chairman, members of the committee. Happy to answer any questions. If not, I close.
Members? Thank you, Mr. Vasu.
Thank you.
If there's no objection, the bill will be left pending. Is there objection? The chair hears none. The bill is left pending. Members, that concludes today's agenda. Is there any further business for the committee to address? If not, the chair moves to adjourn. Is there objection? Hearing none, the Elections Committee stands adjourned, subject to the call of the chair.